But item 13, madam, we have filed our affidavit yesterday, madam. It may be kindly called for. Which one? Item number 13. 13, 13, 1 3, madam.
My lord, in item 14, I have filed an affidavit yesterday that may be called for. Alright.
Please, madam. Madam, I'm preparing for listing a writ petition lordship. I paid 4 fine. Lordship, this matter is related to the NACB Solar Gualpara lordship, that beyond matter lordship. On last occasion, due to scarcity of time, this matter not listed. Some urgency is there. He has been allowed to appear in the written examination, but don't allow to appear in the viva lordship. Retract the written examination. That's why I'm mentioning them. Okay, next Thursday. Next Thursday, no? I mean, Thursday. No, thank you.
Please, Your Lordship, I beg to mention an item for listing, Your Lordship.
Okay.
For listing, Your Lordship. Your Lordship, it's a subsidy matter. It pertains to a subsidy matter which has been long pending since 2021, Your Lordship.
Before they were both taking up bills.
Like,
Yes, no, Mother, on last occasion, your lordship was, we have placed the material before your lordship that the fault is not on our part, fault is on part of them, which they have also admitted. On 1/5/2025, they have sent an email to the petitioner that he is to furnish the documents for consideration. Then on 8th of May, Milord, we have sent it in through email, all the documents, the same set of documents which we tried to upload on the same portal. And ultimately on 25th of May 2025, Milord, they have given the approval after 6 months, 18 days, Milord. And that way we were intentionally deprived from the process of bidding for the person.
You could not upload it on the ground that there were some glitches.
No, Milord, their contention was that the license is not valid. We were advised to upload the valid license. But then, my lord, your lordship will find in their record itself, now license is valid up to 31st of December 2026. So it is only on the ground that the license was not valid. That was not.
Is it for the purpose of empanelment?
Yes, sir. We tried at most, but then after 6 months, they have said that our entire documents have been approved. Which they have admitted. They have been admitted.
Where is your information that your license was not valid? Where is the information given to you that the
Yes, it was in 2024, each in the page 56 of it.
Who is appearing for the central government? Okay, Mr. Bokoto, we will take your matter after some time. Let her come also.
Ethical lodge. Yes. Lord will kindly mark few dates. 2/1/24 was the advertisement.
Yes.
13/8/24, my lord.
13,
13/8/2024. My lord, modalities of marking was evolved by the selection board. Then 21/10/24 was the date fixed for Vaivavus. April 2025, my lord, the process of interview concluded. 21/11/25, select list was published. And 15/3/26, my lord, appointments were made. Now, before I make, my lord, my submission on merits of the case, my lordship should kindly come to page number, my lord, 113.
Yes.
It's part of the advertisement, my lord. Selection process shall be as per relevant provisions of the Assam State Prosecution Service Rule 2023, and date, time, and venue for selection will be intimated to the shortlisted candidate accordingly. So, my lord, the advertisement proclaims that selection will be made according to the provisions of the rules. Now, basically, my lord, before that, one more aspect is there, my lord. If your lordship should kindly come to page number 116.
Yes.
Now, this is the call letter for Vaivavose
116.
116, my lord. Now, please come to serial number 4, my lord. Candidates are instructed to bring the original documents pertaining to educational qualification from HSLC onwards up to graduation and LLB. That is naturally for verification of the academic credential. Then 5, every candidate shall be required to produce before the selection board at least one copy of any application, petition, appeal, etc., drafted by the candidate himself, herself, and filed and registered before a court of law in any criminal proceedings. Every candidate shall be required to produce before the selection board 4 copies of any order, judgment passed by a court of law in any criminal proceeding in which the candidate himself, herself appeared, conducted, and argued the matter. So, my lord, amongst others, 5 and 6 also is very important because it will, my lord, determine the capacity of a person to undertake the job. So therefore, my lord, application has to be there and my lord, 4 judgment has to be there where the petitioner argued based on which argument was made. Now, most interestingly, my lord, this should have been made a part of the application. Application while submitting, because my lord, these were never retained. I do not know, the process records will reveal. Now, tomorrow, if my lord, challenge is made to the selection process to test the validity of the argument, my lord, if the records are not retained, then how will it be possible? So therefore, what I respectfully submit, my lord, these are the, my lord, attributes of an opaque selection process. End of the day, my lord, how can transparency be ensured? By following a procedure which is otherwise, my lord, tested. These are not, my lord, normally whenever any credential is required, it should be part of the application.
No.
Anyway, my lord, records will
No.
reveal. I'm just,
Let us see the advertisement. The advertisement categorically states that these are the qualifications which are necessary
Right.
at 109.
yes, my lord.
Whether the essential must be a graduate of so and so, so and so, so and so. Now, these are the parameters which are being fixed by the selection committee
Yes,
to look into.
yes.
To judge as to the competence of a particular person. The fact
Lots of microphone is
there,
um,
it is as regards the competence of a particular person. But for being eligible is as per the advertisement or the rules framed therein.
yes, yes.
Now, the rules do not mention as to how the merit is to be adjudged.
Assessed.
And normally the rules do not require it. It is the selection committee who has to
Devise
formulate or devise the procedure. It may be subjective for each selection committee whenever it is there. Like, for example, the selection committee which was holding this could be different from any other selection committee who holds it at a subsequent stage. But that is a thing which can this court interfere under 226 on
My
that
lord,
aspect?
my lord, my humble submission is, my lord, end of the day, if the process adopted falls short of, my lord, a transparency is required in a selection process of such nature, certainly lordships can be. I'll place case laws on this point. Now, I'm outlining my argument, my lord. So, my lord, first, what we have seen is that selection will be according to the rules. Second, a very important component of the, my lord, which would determine the merit of the candidate, that was never a part of the record. Because it says, had it been a case that while applying, for example, my lord, when the college teacher selection is made, some, my lord, credentials are required. And always invariably, my lord, they have to apply along with the application. Let us see the application. Yes. 109, my lord.
114.
It says, my lord, educational qualification, there is no difficulty, that is prescribed. Page 109, my lord. Then essential qualification must have practiced as an advocate for not less than 7 years, including practice before the High Court, basically on the criminal side. Then, my lord, for the assistant public prosecutor, different is given. Then please come to 111. Eligibility criteria, this has nothing to do with, my lord, merits of the case. Then please come to, my lord, page 112, documents to be submitted. Documents to be submitted. Duly filled up application form affixing as attested photograph of so-and-so, matriculation, 10 standard, HSLC, etc. Pass certificate and mark sheet of all examination, PRC certificate, certificate from the competent authority, document showing date of enrollment with self-declaration that after enrollment, he has not left the practice as advocate and has not joined any other service, profession, business. In case contrary facts to such claim comes to fore, subsequently his or her candidature shall be rejected as may have been led to termination. My lord, in serial number 8, documents to be submitted, my humble submission is, my lord, the two requirements envisage that page 116 should have been incorporated. That would have introduced clarity and transparency.
But can you challenge them?
Yes, my lord, why not? The
Is-
reason is very simple, my lord, we do not know. My lord, I have
No,
talked
no,
to
no.
many candidates who have appeared in the interview. He said, nobody has asked me any question.
No, that aspect you can't challenge.
No, I'm just saying, my lord, end of the day, my lord, it has to be, in order to give, my lord, legitimacy to a selection process, overall attending facts and circumstances has to be seen, my lord. That these are some of the, my lord, aspects which cannot be lost sight of in determining, my lord, the transparency in the selection process. These are, my lord, opaqueness.
Now, 114 is relevant.
Yes, my lord. 114, my lord.
So your contention is, in these 114, they should have included is submission of the 5 and 6 document as a part of that.
Page, my lord.
Page 114
Yes. Name of
is,
the
is
applicant.
the application
Yes.
format.
Ah.
Now, in this application format, like
Ah.
just for example, a tender document,
Hmm.
where there is a requirement of enclosing those documents
Ah.
in support of your
Yes.
credentials, should have been there in this application. That is your submission.
That would have been, Lord, I mean, there would have been no doubt in that case that, yes, in fact, my lord, I'm told by my learned friend, Lord, recently when the, my lord, senior advocateship was awarded by this honorable court, my lord, while making that application, I think those requirements were NP6. At least how many cases one has appeared, how many decided reported case was actually. Anyway, my lord, these are the one of the part. Now, most importantly, please come to the rules. Please come to 139. This is our, my lord, bone of contention. One 39. Page 139, 19.2. Evaluation of candidates with substantial experience for highly skilled roles like public prosecution would require a specialized testing for assessing the requisite qualities, that is drafting skill, analytical and presentation skill, mental agility, and quick grasp of arguments and quoting judicial precedent, etc. Accordingly, the selection board may devise appropriate method of proficiency cum skill test by conducting a viva voce test. Then, my lord, will kindly come to 19 or 6, my lord, at page 140. After holding the examination, the selection board shall select the candidate in order of merit, taking into consideration reservation for SC, ST, OBC, MOBC, and other categories under Rule 17. My lord, my humble understanding or harmonious reading of 19.2 and 19.6 is that while selecting a candidate, due deference has to be given the skills required, that is drafting skill, analytical and presentation skill, mental agility, and quick grasp of arguments, and quoting judicial precedents. So, my lord, as a test case, the records must reveal that selection board did put questions on these aspects in order to ascertain the eligibility of a candidate as per this. Lord, when in Rule 19.6 it says, according to merit, means this is the merit. Yes, my lord.
What were the questions being put to these 4 petitioners?
Lord,
Have you mentioned what were the questions put to these 4 petitioners in your pleadings?
nothing, my lord.
What?
And nothing, my lord. And my lord, some of the candidates also told
Where's
us.
your statement? There was nothing mentioned.
No, my lord, what question was posed to us that we have not written, but my lord, just let me find out. Yes. Good question. If your lordship would kindly come to para 33, my lord, at page 74. That the petitioners beg to state that the entire selection process is vitiated due to non-disclosure of the marks awarded in the viva voce. No marks breakup or assessment criteria were published either before or after the interview. This lack of disclosure makes the process opaque and immune from scrutiny. Transparency is the cornerstone of public recruitment, and its absence renders the process arbitrary. Candidates were left unaware of how merit was assessed. Such opacity violates the principles of fairness. The Honorable Supreme Court has repeatedly held that transparency is an integral facet of Article 14. Non-disclosure creates a presumption of arbitrariness. The petitioners were deprived of right to challenge their evaluation, hence the selection stands vitiated. That the petitioner begs to state that Rule 19.2 of the Assam State Prosecution Service Rule permits excessive reliance on viva voce without prescribing any objective safeguard. The rule does not lay down parameters, weightage limits, or scoring methodology. This confers unguided discretion upon the selection board. Such discretion is antithetical to the constitutional norms.
No, Mr. Chaudhary, you have not. In fact, it is something like sometimes we mention the law
Yes.
in our judgments. In our judgments, we mention sometimes the law without reference to the facts. It's your petition has been drafted in that manner.
Please come to 42 and 43.
There is no specific averment. Like if we see the
Yes, there is.
subsequent state judgments after Madan Lal also, there has to be specific statements what has happened. In my selection, none of these questions were put. Without that allegation, it is very difficult to support what you are submitting.
No,
Yes, it may be.
Para 42. That the petitioners beg to state that respondent authorities have acted in a wholly arbitrary and unreasonable manner by ignoring the long-standing past practice, proven track record, and demonstrated competence of the petitioners in prosecution service. Petitioners have been continuously engaged as public prosecutor, etc., for several years prior to the selection. During such engagement, petitioners have conducted numerous criminal trials, argued bail matters, laid evidence, and assisted the court in administration of criminal justice. Therefore, their performance was never found wanting, nor were any adverse remarks or disciplinary proceeding ever there. On contrary, the petitioners were repeatedly entrusted with so, which itself reflects institutional confidence in the competence and integrity. In previous selection and renewal, such past prosecution explains was treated as a vital community factor. However, in the present selection, respondents have completely ignored the petitioner's past service and performance. The viva voce process did not meaningfully assess or even consider their actual professional work. No marks were disclosed to indicate whether experience was evaluated at all. Such disregard of
This is again, Mr.
This is
Chaudhary,
again
different.
regarding experience.
And in fact, it shows that why you should have been considered.
Yes, yes.
very difficult to make that submission.
No, no, Milord. What, anyway, I'll try to deal with that aspect, Milord. Now, my argument based on Rule 19.2 and Rule 19.6 is, Milord, the selection records must reveal that the selection board had due regard to these requirements while making the selection. And at least, Milord, the minutes of the selection proceeding must disclose, number one. And one of the most vital aspect in this case is, Milord, on 13/8/24, the modalities were conceived by the selection committee. Milord, 13/8/24, in their affidavit, they have disclosed that, Milord. But this was never made known either to the candidate or anybody else. So how the candidate knew that they will be assessed on these parameters? That is what we have indicated in our affidavit in reply. If your lordship would kindly take their affidavit, Milord, where they have taken this stand. Please come to para 12 of their affidavit at page 157. That with regard to the statements made in paragraph 15, 16, 17, and 36 of the writ petition, the deponent denies the allegation made therein and further begs to state that there is no conflict between Rule 19.2 and Rule 19.6 of the Assam State Prosecution Service Rule. Rule 19.2 provides the mode of assessment, while Rule 19.6 mandates the preparation of select list on merit with regard to reservation policy. It is submitted that for conducting the said recruitment, 3 selection boards were considered with the following composition. Then Lordship may skip over to the next page. In the joint meeting of the members of the selection board held on 13/8/24 to work out the modalities and procedure to be adopted, members of the selection board have decided to conduct specialized testing only by adopting viva voce, having regard to Rule 19.2 of the rules and Clause 2 of the notification dated so and so. In the said joint meeting, it was unanimously decided that viva voce test would comprise 100 marks, with 70 marks for assessing the requisite qualities, drafting skill, analytical presentation skill, mental agility, and quick grasp of the arguments and quoting judicial references, 20 marks for assessing the requisite qualities of personality and temperament, 10 marks for overall academic performance of candidates by taking average of all marks up to the graduation level. Now, my lord, when was this published? Who knew it? Huh? Now, if your lordship would kindly come to page 162, 6, sorry.
You'll get that at page 169.
My lord.
169.
Yes, my lord.
Top paragraph.
Yes. In the joint meeting, it is unanimous decision of all members, including the chairman of the 3 selection. Yes, my lord, I am not disputing that. But the question is, it was never made known to anybody. Now, please come to the next para. This is important. It has also been further decided that in order to aid the assessment of drafting skill, analytical presentation of skill, mental agility, and quick grasp of argument quoting judicial references, the respective candidates would be required to produce before the selection board at least 1 copy of drafting of any application, petition, appeal, etc. done by the candidate himself, which has been filed and registered before a court of law in any criminal proceedings. The candidates shall also be required to produce 6 copies of any judgment that may have been passed by a court of law in any criminal proceeding in which the candidate himself appeared, conducted, and argued the matter. In respect of any matter, these are for different. Now the question is, my lord,
This seems to be the follow-up for conduct.
yes.
This petition which is there. Strategic in order to assess the thing,
Yes.
they will have to produce.
They-
will be required to produce 6 copies of document that they have to pass by a court of law. Have to be-
Yes, my lord, possibly they took note of what is indicated in the call letter. Now, my lord, this decision of the selection board. Of course, my lord, there is no dispute that the selection board is authorized to devise its own procedure. But was it not incumbent upon the authority to make it known to the candidates? Otherwise, how would candidate come prepared, my lord? So this is the openness, my lord. If you are insisting on a criteria, was it not incumbent upon you to make it, I mean, to publish it?
Required.
My lord, yes, my
Is-
lord.
Show me
Otherwise,
a,
how will they know?
no, show me a judgment where the
No,
court says
any criteria of selection, it has to be made known beforehand. Now, I'll place one judgment, my lord, where all these aspects have been covered.
because you won't allow me to first write a judgment on this point. Let the Supreme Court help you.
Anyway, my lord, then please come to the last para at page 169.
159.
169, the last para. It is clarified in the joint meeting that requirement to bring one copy of drafting and copies of judgment orders by candidate is not to be construed as an eligibility condition, but only to facilitate the evaluation of the candidate. The follow-up action of the issuing call letters to the respective candidate shall take place and be done as per schedule to be decided by the respective boards. Now, they have also indicated, my lord, merely because if any of the candidate, when meets 5 and 6 of the call letter, that by itself is not a guarantee that they will be selected. Eventually, this will be utilized for testing or evaluating the merits of the candidate. When, my lord, the selection board itself emphasizes that the judgment should be eventually used for testing the eligibility and, my lord, merit of the candidate. Therefore, the selection board records must reveal how this judgment and the petitions were taken note of and how marks were given. Now, my lord, therefore, my lord, in this case, what we find is, my lord, merely because the selection committees were headed by retired honorable judges of this honorable court, that by itself, my lord, it is not suggested that the requirement of Article 14 and 16 is not required to be followed. Merely because of the person constituting the selection board by itself is not also an authority that it has to be taken as if it has been done fairly and transparently. No. If it
Mr.
is
Chaudhary,
pointed-
I'm absolutely with you only in this point.
Anyway, now, my lord, therefore, my lord, what the selection record will have to ultimately reveal is, my lord, how the eligibility or merit of the candidates were assessed, having regard to the 4 attributes indicated in the Rule 19.2, and, my lord, 5 and 6 of the call letter.
But
I-
without specific allegation,
My lord,
you are making allegation in the abstract
no, my lord,
that I
please-
should have got this much. You are saying that you have very experience, you have been given out there,
There is
how
a
much
case.
marks out should have
These
given.
aspects came to light only after the affidavit is filed. Only after the affidavit is filed, we came to know
But you
that
filed
this,
the affidavit in reply.
that's right. Yes,
So in the reply, have you raised that?
yes, yes.
It's in my marks.
Please have the affidavit in reply, my lord. No, my lord, mark has not been disclosed. Therefore, we are not in a position to make any comment on that. And this honorable court has already directed them. Please come to paragraph 5, my lord. That the petition, page 329. Para 5, my lord, there in their affidavit, they have taken the plea of, my lord, estoppel by participation. To deal with that, we have said this, that the petitioners beg to state that the plea of estoppel raised by the respondent is misconceived. The irregularities forming the subject matter of the present challenge. I'm sorry.
When did you file the reply? Yesterday. Give a copy.
Milord, will kindly come to page 329, Milord. Para 6. Para 5, we have dealt with that issue of Milord estoppel. 6. That the petitioners beg to state that respondents have admitted that the methodology and marking pattern governing the selection process were evolved in the meeting held on 13/8/24 and were not disclosed to the candidates prior to the selection process. Respondents have further failed to disclose any objective evaluation record demonstrating how marks were awarded and how comparative merits were determined. So in the affidavit, Milord, they should have disclosed this. That the petitioner begs to state that despite the specific direction of the Honorable Court, order dated 3/1/30/126, requiring production of records of selection proceeding, respondents have failed to produce candidate-wise assessment records, comparative merit statement, eligibility verification record, or other contemporaneous material. In these circumstances, respondents assert that regarding fairness, transparency, and merit remain wholly unsubstantiated and warrant an adverse inference. Now, please come to paragraph 18, Milord.
Yes.
That the statements made in para 12 of the affidavit in opposition are not correct, and as such, the same are denied. The deponent states that the minutes of the joint meeting dated 13/8/24 relied upon by the respondent themselves demonstrate that methodology and marking pattern governing selection were formulated more than 7 months after the issuance of the advertisement and were never disclosed to the candidates beforehand. The respondents have admitted that aforesaid test was structured with 70% marks for assessing drafting skill, analytical presentation, mental agility, legal competence and allied attribute, 20 mark for personality and temperament, and 10 mark for academic performance. Respondents have further admitted that candidates were required to produce copies of the pleadings, petition, judgment for facilitating such assessment. Neither the advertisement nor any prior notification disclosed these assessment parameters, their respective weightage, or the requirement of producing such document. Respondents have failed to disclose any objective criteria, benchmark, marking guide, moderation process, or contemporaneous assessment record governing the award of the marks under the aforesaid heads. Significantly, while assessment involved multiple attributes including drafting skill, legal knowledge, and analytical ability, the respondent decided that each candidate would be evaluated through a viva voce of only 6-7 minutes. Respondents have furnished no material to demonstrate how such brief interaction could ensure fair, objective, and
Now, where are you getting the respondent decided that each candidate would be evaluated?
yes, it is there. Page number 169, Milord. Page number 169, the third subpara. As it is established principle having approval of the Honorable Court, providing that if a selection is held solely on the basis of viva voce test, ideally testing time ought to be 6-7 minutes. Accordingly, it is decided that time to be devoted to a given candidate would be 6-7 minutes. Now, Milord, may I be permitted to read the last part of para 12-18, Milord, at page 335. Respondents have furnished no material to demonstrate how such a brief interaction could ensure a fair, objective, and uniform assessment of the candidates of numerous parameters identified by the selection board. Further allocation of 10 marks toward academic performance on the basis of graduation and LLB was neither disclosed in the advertisement nor made known to the candidates prior to the selection process. Application of such undisclosed criteria having a direct bearing on preparation of select list renders the selection process arbitrary and non-transparent and unfair. Petitioners therefore reiterate that averments in so and so of the repetition are denied. So and so reiterate. Now, my lord, another aspect which lordships will certainly take note of is that lordship kindly takes the milord writ petition. Yes. Now please come to paragraph 30 of the writ petition, milord. Page 72. That the petitioners beg to state that the entire selection process is further vitiated on account of wholly irrational and arbitrary shortlisting adopted by the respondent. For merely 2.99 advertised posts, the respondents called clearly 7,000 candidates for viva voce proficiency cum skill test. Such mass calling of candidates for interview defeats the very purpose of shortlisting, renders the viva voce unmanageable, and inevitably introduces subjectivity, arbitrariness, and pick and choose selection. Honorable Supreme Court in a curtain of judgment has categorically held that ordinarily the number of candidates called for interview should not exceed 2 or 3 times the number of vacancies, and that calling an excessive number of candidates for interview itself constitutes arbitrariness and violates Article 14 and 16. The court specifically observed that when a large number of candidates are interviewed for a small number of posts, the interview ceases to be reliable or objective mode of assessment and becomes vulnerable to manipulation. In the present case, calling approximately 7,000 candidates for only 299 posts, that is more than 23 times the number of vacancies, demonstrates complete non-application of mind and is expressly contrary to the law laid down. So this is an aspect. And if your lordship would kindly come to their affidavit, paragraph 4, my lord, where they have replied to this.
But probably it's a fair point taken at time to the law. But can you raise? Can you raise it? It's a good point, but can you raise?
Having participated.
This is the problem which I. Yeah, this is a. And not only that, I am a bit.
Well, I never knew that 7,000 has been called.
No. So it's a different thing. 7,000 has been called, but you are that is a case of due diligence. How did you know later on? Did you go for an RTI?
Well, from their affidavit.
How can it be when you are filing a petition? The affidavit comes later on.
Now, before filing of the writ petition, we got to know that it was 7,000.
Where is your statement to that effect? That later on you will come. But my question is, this is one. Secondly, another thing is normally the Supreme Court always says that there should be a written. And
Followed by viva voce.
But that is, these are things. Can you tell?
No, my lord, my humble submission is very simple. Ideal situation is there should be written test followed by interview. And interview component should not be more than 15 to 30%. That's what the preponderance of view of the Supreme Court. Now, my lord, in case of mature personality, as Supreme Court has said in Anjara, that it can be by 100% interview also. But my lord, there the process has to be fair. It has to be transparent. At least you must indicate how this interview will be assessed. Here in this case, my lord, nobody knew anything. My lord, it's a different matter. Somebody were selected, somebody were not. I'm not on the merits of selection. I'm on the decision-making process. We participated. My lord, when we were not posed, many significant questions as is being projected in the affidavit, then we were surprised, my lord. No, my lord, lordship will, I'll place 2, 3 judgment at that. Anyway, my lord, let me first go by point wise, then I'll articulate my argument. I have already argued regarding Milord 19.2 and 19.6. Then I have argued, Milord, that 7,000 candidates only interview or calling 23 times the number of vacancies is something is abhorrent. And thirdly, Milord, what about the Milord contemporaneous record of selection? Because rule itself says, please come to the rules, Milord, page 139. Rule 19.4. At page 139, a true and faithful record of the proceedings of selection board authenticated by the chairman shall be maintained. Then
Now, show me one thing, where is the select list? Select list with marks.
yes,
Normally there is a select list with marks.
125 Milord. $125. No mark, nothing indicated.
Thing with marks.
No. They have not
Marks
given,
have
not there.
disclosed.
No. And in fact, in the very first order, my Lordship directed them to produce indicate the marks and all. They have not done. In fact, records will reveal. They may not disclose it to us, but they should have disclosed to the honorable court, my Lord. Yes, yes. First order too. Yeah. In fact, your lordships order detail 3126, paragraph 16. The state is directed to produce the records of the selection proceedings and more particularly in respect of the allegations so made by the petitioners on the next day.
So let us see now, therefore your arguments are, if I may just formulate. First, you say that or we may just reformulate taking into account the sequence, not the sequence. On 13/8/2024, there was a selection committee meeting. In that, they formulated certain parameters. In those parameters, for the first time, they devised the procedure that they will be looking into certain judgments. Now, in these judgments or all these contemporary case, have been actually a part of the litigation itself. So that in conformity with Rule 9, Roman 2, this could have been proceeded.
This could have been tested. But for example, my Lord, today I am laying a challenge. In the absence of that prescription, my challenge has become incongruous.
Now, the second aspect is, you say that 13/8 they have decided. Thereupon, universal was held on 21/10/2024. 13/8 was almost 8 months after the issuance of the
Advertisement.
So therefore, they should have disclosed before the candidate prior to initiating the going ahead. with the
In fact,
results.
call letters. In fact, issuing the call, before issuing call letters, my Lord, they should have indicated.
Indicated where, in which line they should study and all. Number two. Number three is 7,000 persons have been selected, have been called for interviews. These are all interviews. 6 to 7 minutes have been given. They have been assessed on 100 marks on the basis of that. And if these 7,000 persons have been done, there should have been, you say that, proper materials should have been taken into consideration, and
Yes.
what are the marks and how, what was the basis on which it's done?
And my lord, the judgments were not retained. The pleadings and the judgments were not retained by the selection board. On the contrary, my lord, rule says the records should be preserved. The, so today, my lord, I am laying a challenge. How do I prove it?
You are referring to rule 19,
19.4,
which requires
preservation of
payment
record.
The judgments pleading not kept on record.
Yes. The selection board did not retain the, my lord, judgments.
Mr. Chowdhury, one thing, you are showing 6 judgments. The judgments are not retained. How is it possible to go ahead and carry out an assessment of a candidate?
Yes.
More particularly public prosecutor, which requires 6 judgments in 6 minutes.
No, it's not possible. That's why, my lord, it goes to the root of the matter. I'll place a direct judgment on that point regarding the number. And my lord, we have specifically made that allegation. There is no reply to that. The evasive replies are being made. So, my lord, this is how we are to find out the eventual transparency in the selection process. If there is any doubt, that doubt has to be resolved in favor of the, my lord, affected parties, persons who are before a lordship. This is not a doubt which is to be resolved in favor of the selection. Now, my lord, I'll place that judgment of the Supreme Court, my lord. My lord, regarding how we came to know about the number, my lord, when we check from the website, then my lord, in this form, my lord, it is uploaded. So from this we got to know. Hey, this is how, my lord, it was uploaded in the website. So from this we tentatively arrived at a figure. Yes.
Or is it the same board or different board?
My lord, these are the, my lord, names which were uploaded as to Google or called for internet.
Now, you see, if we see this particular document,
Hmm.
9:30 AM, 14, first half. And the second half starts at 1:30. First half, 18 candidates are to be looked at. Whereas the second half, 17 candidates from 1:30. Is it in respect to all the 3 boards?
I think this reflects in respect to one board. Not three.
It doesn't say so.
Now, Lord, the Lordship's kind permission, can I place one judgment of the Supreme Court, my lord? Please have that judgment, my lord, 2024 SCC online SC 2931. Please come to para 2 and 3 for the facts. The matter pertains to 31 vacancies that arose on the post of laboratory attendant pursuant to an advertisement issued on so-and-so by PSCB. The eligibility criteria to apply for the said vacancy were that candidate must have qualified 10 standard with science and Punjabi as subject. A total number of 4752 applicants applied for these posts. As part of the initial screening, a preliminary written test was conducted on 28/9/2011, on the basis of which total 1952 candidates were shortlisted as per determined benchmark of the cut-off score. Ideally, Miller, this process should have been adopted. These shortlisted candidates were subsequently called for the next segment of selection process, that is interview stage. Due to sheer number of candidates, interviews were conducted over multiple dates, culminating in completion of the selection exercise. Thereafter, final list of selected candidate was published on 4/4/2012. So these are the facts. Now please come to paragraph 15. Now, para 14 will not lays down how the marks will be evaluated. Para 15. Therefore, the merit of the candidate was to be assessed on cumulative score of 50. These aforesaid criteria, however, were not specified in any rule or instruction. In fact, the said criteria came to be adopted only when the interviews were to be held, as in our case. It must be noted that despite the fact that records were called for by the learned single judge, PSCB was unable to produce any material to show that criteria for selection had been decided upon prior to the onset of the entire selection process. Therefore, the learned single judge concluded, on the basis of the file noting that were produced before him, that selection criteria were fixed only on the date when interview were to commence, that is, after the result of the written test had already been declared. In fact, it is also equally important to note that no deliberation in the form of minutes of the meeting by the selection committee have been made available, either to prove that PSCB fixed a criteria of selection before entire process had commenced. On the contrary, it is apparent that the criteria decided upon, a benchmark eligibility cutoff of 33% to call candidates for interview stage, was made after entire process had begun, tailor-made, and did not have any nexus with the object sought to be achieved, that is, shortlisting of the candidates on the basis of merit either. We must bear in mind that the marks secured by the candidates in the written test were not considered or given any weightage for such selection either. Additionally, in the recruitment process, where there are only 31 number of posts up for grab, subjecting an excessively large number of candidates, that is 63 times to the number of vacancies to the interview, would inevitably lead to a situation where even those candidates who may have performed very poorly in the written test are granted an unfair shot at the appointment, and many more qualified candidates were potentially overlooked. In such a scenario, therefore, limiting the number of candidates for viva voce segment becomes essential for several reasons. Firstly, it enhances the efficiency of the selection process by providing for more thorough and fair evaluation of the candidate. Secondly, by restricting the number of candidates, the process becomes more transparent and less susceptible to allegation of favoritism or bias. Consequently, it ensures that only the most qualified candidates based on an objective criterion proceed to the stage of an interview, helping maintaining the integrity of the process, upholding the principles of meritocracy, and reducing chances of oversight. In the light of these considerations, the impugned judgment can be sustained only to the limited extent of eliminating marks awarded for the rural area criteria. Therefore, we are of the view that direction given by the learned single judge to commence the selection from the stage of written test deserves our approval. Accordingly, candidates only up to 5 times the number of vacancies should be permitted to appear in the next segment of recruitment test, that is interview. The direction given in clause 4 of the para 37 in the judgment of the single judge dated so and so for assignment of marks for qualification, experience, knowledge of science, practical, equipment, and interview should be kept in such a proportion that marks for knowledge of science, practical equipments, and interview together should not be more than 1/3 of the total marks. The suggested criteria by learned single judge in the judgment may address a part of the requirement of assessing merits of the candidates. So, my lord, here in this case, my lord, 63 times was called for because against 31,1925 were called. In our case, it is 23, but Supreme Court has said it should not be more than 5 times. And my lord, similarly, as in our case, here also, the modalities were, cited after the call letters were issued. Therefore, it said,
but, give me-
yes, sir.
The court went into another aspect, that there were two tests. One was the written test and the other was the promotional. In the written test, there were some persons who not do well. But on account of a cutoff, they were brought.
So even people with lower merit were also included.
And they got higher marks. And because of that, they got selected. Whereas there were people who got higher marks in the and they got lesser marks near the school. And it is under such circumstances that there was a disparity. Further, when that there was a necessity of having a further requirement of further screening, because there would require another screening for making it to 5 times, if it is not 5 or 7 times of that. But here we are also here we are asking, yes, ideally they could have gone, but after all, state services, they should have gone for a test. But this is available to any person who have crossed 21 years, 21 or 25, whatever may be the age, they could appear. And there could have been many, and here we see around 7,000 agencies. They could have ideally they should have a test that there are 40. Another thing is, the lawyers, they don't like to give the examination. Having a written test and then for the year, we don't get the good.
My lord, to be honest, my lord, our challenge is not to the fact that the written examination was not a part of the selection process. That we have not made any challenge on that.
But then if it is not, how do you challenge the 27 times? How do you challenge the 27
No, my lord,
times?
that's where we have challenged the rule. There we have played it. taken this point. That is
That is a different thing. But if you raise this issue of 27 times,
No, my lord, here in this case, what I would like to ideally argue, my lord, for having laid the facts. Now, my lord, this prosecution service is as important as any other job. Therefore, people with proven, eligibility should alone be selected. Now, my lord, kindly see, here, my lord, some hidden criteria were adopted. As far as candidates are concerned, these are hidden criteria. We never knew. Only when the affidavit was filed, then only we got to know about how they have evolved this criteria. And having evolved, so therefore the selection proceedings must reflect that how these were applied in the selection process. If it is not evident from the records, then my lord, it has to go. It has to start again from the stage of interview by, declaring the modalities. Well, it's an abuse of the process. How can you countenance an action which is not transparent, which is wholly opaque? Well, we don't even know even today who has secured how much mark. This select list does not indicate the mark. Anyway, Lord, select list may not necessarily indicate mark. I am not saying that is a requirement. But my lord, at some level, at least in the website, it should have been disclosed that these are the persons who participated, these are the selected, these are the marked.
yeah, the mark has to be informed. They don't quarrel that the marks has to be informed because they have when a person gives an examination, he should not only be informed that what is that you have not selected. Have to be informed. What do you mean? That is my feeling on that.
Yes.
But that not providing the marks will not vitiate the selection.
It will not vitiate the selection, but my lord, ultimately, my lord, why it is said, my lord, kindly bring in the analogy of a speaking order. It is said that an administrative authority, while passing any order, they must pass a speaking order. The reason is, my lord, it brings clarity to the decision making, number one. Number two, it obviates any arbitrariness. Third, it discloses the reason. If somebody is aggrieved by that order, he can assail it, saying this ground which has been taken while rejecting my claim is bad on account of this reason. If the reasons are not disclosed, that gentleman is deprived of laying a challenge to that order, which is again violative of Article 14. So, well, at the end of the day, in a selection process also, though stricto sensu, we cannot apply those principles. At least bare minimum facts to give legitimacy to the selection process, my lord, it must be evident. End of the day, they are making recruitment, public recruitment. So this, my lord, there in their website, they must disclose. Then we could have found out, I have got this mark, this candidate has got this mark, I know him, this, that. Is he so competent that you will get 80, I'll get 30? Something like that, my lord. End of the day, my lord, nobody can stop people from making an assessment on himself or somebody else. So here is a case, you are making a recruitment, that too for 299 posts, and you are paying a very handsome salary. You have adopted a procedure which is absolutely open. Nobody knows how.
Just for example, the law officers exams for state bank.
My lord.
Law officers exams for state bank
Yes.
or law officers exams for the Central Reserve Police Forces and all these things. They have a law officers. exam.
Yes. Yes.
But they have I think, a written test.
Yes. Normally. Well, ideally, at least, my lord, at least some screening should have been done, my lord, based on certain criteria. In other states, they do, my lord.
My only thing is, how could for public proceedings, how could the
No, my lord,
selection
now
within
my
6 minutes?
humble submission is, my lord, our allegations has to be tested qua the records. The records must reveal, my lord, as an examiner taking part in an examination, it will be very difficult for us to, my lord, lay bare, my lord, everything in a, my lord, convenient manner. End of the day, we are not privy to what is there. In that view of the matter, Lordship will kindly consider our predicament also. End of the day, my lord, there has to be a selection which is fair. In, my lord, in MP Sugar Mill's case, when the Supreme Court said, when it comes to permitting government to resile from the promise they made, then Honorable Supreme Court said, my lord, it is the court's satisfaction. End of the day, therefore, the issue is whether this selection process inspired the confidence of this honor. If it does, end of the matter. If it does not, my lord, it has to, my lord, the ball must roll again. My humble submission is, my lord, it's absolutely a vague thing, lord. I'm not seeing, lord, it's a case of malice in fact. I'm not alleging malafide because I do not know anything. I cannot allege malafide in anything. But the manner in which the things have been done, lord, it does not inspire the confidence.
Okay, any other thing?
There's one more judgment, lord. On contemporaneous record.
Now, one thing which we are submitting out here to the effect that the selection board decision, how they will devise the selection, it always come after vacancies are notified.
Exactly, before advertisement. Selection criteria, my lord. My lord, that judgment I haven't brought. That's just, my lord, subtle position. Selection
Is it
criteria.
Is it required?
Yes.
I don't think so.
No, my lord, selection criteria must be disclosed before the selection process starts. Otherwise, my lord, why
No,
this
no,
concept of.
before the selection process starts,
Yes.
but not at the time of advertisement. My question is,
No, my lord, Supreme Court says selection process starts with the issuance of advertisement.
no,
And yes, there are judgments.
I don't think.
My lord, I'm sure, my lord, there are judgments.
Where after notifying the vacancies, then the selection.
No,
board
my lord,
divides the
no.
procedure.
No, my lord, Supreme Court has said selection process starts with the issuance of advertisement and it ends with the appointment.
Understood. But at the time of selection, prior to, because then the role of the selection board will come in.
No, not, no, not, actually.
So are you therefore submitting that there the selection board at the time of notifying the vacancy will notify? At that point of time, the selection board has to be set up prior to that, and they will notify the modalities of the selection and put it in the advertisement.
No, no, I'm not
Wait,
saying that.
no,
No, I'm not saying that. But what I'm saying is, normally any selection criteria are to be made known at the advertisement. Yes, there's an exception to this, Miller. Now, how the interview board will conduct the interview, how they will, assess the candidates, that is their prerogative, then they can devise their own procedure. But it is not to be kept in the drawer. It is to be made known before issuing the call letter for interview. Ideal situation is there will be written test, shortlisting, then interview will be, board will be constituted, they will devise the procedure, then call letter for interview will be issued, where they will disclose the, selection criteria. That's the ideal situation. And my lord, if we go by that analogy, that's to when the selection process starts. Generally, Supreme Court said it starts with the advertisement, ends with
maybe, but after the notification is given, then the selection board will devise up the method. Yes, the method, the criteria in which it is to be carried out, or the criteria, just for example, if it is merit cum seniority or what are the minimum benchmarks to be put out there. These are criteria which are to be evolved by the selection board at a later point of time. These are there. But there has to be the basis. Now, here we have the basis in 19.2. This is the basis. Now, on the basis thereof, the selection board have taken into consideration that this is how the manner in which we are going to give these marks. Where is it that it is required to be disclosed? And one. Secondly, where is your prejudice to that effect that if you had known it, you would have prepared in this manner differently? Because I
on
don't
that-
think this is
on
the law.
that specific point, I can find out case laws and give it to Lordship by
Well,
tomorrow.
I don't take normally service matters, but I always keep on taking the Gauhati High Court matter. That is the
Now the Supreme Court says, my lord, we therefore answer the reference in the following terms. Case Prakash Pathak. As recruitment process commences from issuance of advertisement calling for application, ends with filling up the vacancies. Eligibility criteria for being placed in the select list notify that the commencement of the recruitment process cannot be changed midway to recruitment process unless the extent rule so permit, or advertisement which is not contrary to the extent rule so permit. Even if such change is permissible under the extent rule or the advertisement, change would have to meet the requirement of Article 40.
There is no quarrel with that proposition. My question is, you cannot change tomorrow what is there in 19.2, which is there a part of the advertisement of the rules. And later on, by carrying out an amendment later on to 19.2, you cannot in the midway say that the selection is different now. You cannot.
That is 19, which there we are not disputing. But the selection board on 13/8/24 having adopted a resolution. In fact, that these are the criteria which we are going to will not follow.
Unless you convince me with a judgment, bind me. If I'm not bound, it's very difficult on this.
My lord, paragraph 52 of test path of my lord. Thus, in our view, appointing authority, recruiting authority, competent authority, in the absence of rule to the contrary, can devise a procedure for selection of candidates suitable to the post. And while doing so, it may also set benchmark for different stages of recruitment process, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before commencement of the recruitment process. The constitution bench. Test Prakash Pathak.
Let's see.
Yes. Test Prakash Pathak. citation. 2025 to SCC page 1. Para 52,
25, no?
yes, page 1. 2025
Which SCC?
to SCC. Page 1. Now, my lord, exactly what I submitted, my lord, that is the view has been expressed by the Supreme Court. Last sentence of para 52. However, if any such benchmark is set, the same should be stipulated before commencement of the recruitment process. But if the
Paragraph
52, my lord, at page 33. What is clear from the above is that object of any process of selection for entry into public service is to ensure that a person most suitable for the post is selected. What is suitable for one post may not be for the other. Thus, a degree of discretion is necessary to be left to the employees to devise its method, procedure to select a candidate most suitable for the post, albeit subject to overreaching principles enshrined in Article 16. And also the rule statute governing service and reservation. Thus, in our view, the appointing authority, recruiting authority, competent authority, in absence of any rule to the contrary, can devise a procedure for selection of a candidate suitable to the post. And while doing so, it may also set benchmark for different stages of recruitment process, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before commencement of the recruitment process. But if the extant rule or the advertisement inviting application empowers competent authority to set a benchmark at different stages of the recruitment process, then such benchmark may be set at any time before that stage is reached, so that neither the candidate nor the evaluator, examiner, interviewer is taken by surprise. Then
let's
53.
see, now let's come to page 139.
Yes.
So isn't it subsequently? 19.2.
Yes, Miller. Accordingly, selection board may devise appropriate method of proficiency tests by conducting the biopsy.
So it is
Decision of-
subsequently.
Yeah.
Subsequent to that. The selection board, you see, the selection board does not come into existence prior to the recruitment process being initiated by way of an advertisement.
Simultaneously, when the posts are
Yes,
advertised.
so therefore the selection board will do it subsequently.
Yes.
So therefore, subsequently, it will be done subsequently. It cannot be put in the advertisement.
Normally, what happens? They have to, end of the day, it is a public recruitment. Therefore, every stage they have to notify that for so-and-so selection, now we are going ahead with the process of interview. Therefore, we have constituted the selection board, XYZ. Then, my lord, if the interview board devises its own procedure, then that must be uploaded on the website.
Now, you see, the advertisement was dated, advertisement was dated 2/1/2024.
Yes.
Now, this member constitution was done on 26/2024.
My lord.
The selection board was made only on 26/2024.
Yes.
So it will be obviously subsequently. Okay. Now, your submission is on 13/8 when it was devised.
Yes.
Then you ought to have been notified.
They have uploaded everything in the website other than this. Other than this, everything, and my lord, the marks secure.
Marks we are taking.
Yes, marks, my lord, and this. Otherwise, everything is, my lord, available in the website. Now, my lord, my humble understanding is, my lord, before you call for the interview, then you have to constitute the board. That you must notify. Then the board will have its own, my lord, meeting, decide how to go about. Then what they decide has to be also uploaded. Otherwise, how does the candidate?
So here, so Mr. Chaudhary, here will be therefore a case of prejudice
Yes.
to you. That you didn't know these standards and as such,
Yes.
where is the allegation to the pleadings?
No, my lord. Lordship will kindly see in the facts and circumstances. It's true, my lord.
No, because you see, you have submitted a reply or whatever may be that is it your case that you did not have the 4 or 6 judgments?
As the lordship will take in a case where one would try to make a roving inquiry. We are not trying to asking your lordships to make any roving inquiry that the rest of any pleadings, my lord, we are calling upon your lordships to enter an area. Here, my lord, what we are saying is what is the fallout of the manner in which the action has been exercised, the power has been exercised. If something flows from, my lord, an arbitrary exercise of power, that is within the, my lord, permissible parameters, my lord. Supposing, my lord, we are alleging certain malafide against some members, there I need to come up with this specific piece. Here, my lord, whether any standard was maintained to ensure transparency. In such area, my lord, to come up with specific pleadings, it is required, but even if it is not there, having regard to the record, lordships can always look into this allegation, my lord.
Can I?
Yes, my lord. To ensure, my lord, fairness in the selection process and to justify your lordship's conscience that all is well, then certainly lordship can look into that. Then why do we call it, my lord, the doctrine of lifting of veil? Can you see the attending facts and circumstances?
I'm making my the judges will not, but I make the mind very clear. Yeah. My only problem is first you have participated.
That I can overcome.
I have to take you out from modern law's problem.
No, my lord, Madan Lal, then my lord, after Madan Lal, my lord, then that Rajkumar Rajshakti's case is there. My lord, in our High Court, my lord, in that police recruitment case, this plea was taken. A coordinate bench of this honorable court rejected it. Eventually, matter went to Supreme Court. But on that count, the selection.
No, I'm not on that. So, what you see, the basis on which normally Madan Lal is taken as an exception is that it is only when you participate in the selection process you may come to learn that there is
Some
these illegalities. So therefore, there is nothing on the process being done, but the illegalities which have been committed. Then only you come outside the realm of Madan Lal.
In fact, your lordship has referred to an order in the first order.
I mentioned about that.
That just
I mentioned it. But my question is, if these are special circumstances by which you take out Madan Lal, isn't it required for you to have appropriate pleadings? My question is there. There's the problem again.
no, my lord. Ideally, yes. I can.
Because otherwise, what you are asking, that this court looks into certain aspects, which is not with specific allegation to cover up Madan Lal.
My lord, my submission to that respect would be whether it is a PIL or a requisition, lordships interfere because there is an element of public interest is involved. Element of public interest. Now, my lord, in a PIL, the rule of locus standi is relaxed, and otherwise, lordships insist that an aggrieved person before should be your lordships. Now, while trying to find out what is in public interest, I think this strict rule of pleadings, my lord,
That is required. Otherwise, you don't come out from Madan Lal. That is the Madan Lal law still holds. But this is the only way out. My only thing is,
Madan Lal, as I understand, is a general proposition of that once you have participated in a selection process, then you cannot turn around and will not make a grievance about something wrong in this case. But post-modern law, there are judgments.
But in 2023 also, three judges.
No,
bench
there are
have-
judgments.
Yeah.
But at the same time, there are other judgments also where the Honorable Supreme Court has said, my lord, if the illegality comes to the notice subsequently, then
Yes. Then it's specific pleadings. My problem is this, unless you say that these are the parameters which have held it,
that we
and
have
for that I am prejudiced.
No,
Where is that
no,
prejudiced?
in so many words, it is not there, but in roundabout manner, we have said that. Differently. I think I should read that paragraph once again, Milord. I think.
Yeah,
Nice
yeah.
for a 5 minutes, you can. I think that.
And Mr. Sakya, I'm telling you one thing. Yesterday they have filed it affidavit in reply. Have you gone through it?
Just now, few lines I have gone to because hearing comments
I
last.
think, don't you think that I've heard it, but don't you think there is a requirement for you to meet up some of the requirements which are more particularly in paragraph 5, 6, and 18, some rejoinder to the effect that these are different allegations which are not there in the petition.
Absolutely.
Because tomorrow, if I decide without those allegations being countered, you may have a trouble. Or you may take a plea that no opportunity was granted. Either plea.
So in the course of hearing, I have come to know that an reply has been filed. Has come
Because
to
the
office to-
reply had just come to me.
Yes.
Because I asked him to file the affidavit.
Lines here.
In fact, he was supposed to file the reply by 8/6.
Only thing is that seven, they have said that the candidate wise assessment records were not there. Anytime we can produce it.
No, understood. So therefore, my question is, I have granted them the permission or the liberty to file the reply by 8/6.
Actually, they filed their affidavit on 10/6. That's why the
No.
private
They filed-
respondent,
No,
not state, private respondent.
no, this reply is not filed against the
State
private
or-
respondent. This is against
No,
the
state
state.
filed early.
State filed it on 13th May. So therefore, I gave them time till 8/6 to file. They filed it later on because this is an issue, I think, more particularly these are new things which are not a part of the original pleadings. Normally, what happens in a reply is, you are replying, you don't add anything. Additional affidavit, you explorate something which is there.
So, Lord, I'll go through it right now. By producing the record, if it will suffice, then we'll not file
You
anything.
have a look at it while I
Oh.
hear him, but the only thing is, if you want to file a
Because their
reply, think
basically
about
the contention is that we have not produced the record.
the records. This court have already called for in the original order. First order, I have already called for the records, and the records will be just looked into. But one answer to that effect, I have a only thing is, on 13/8/2025, 24, 25, 24, you have formulated that within
That
six.
I will overcome, Lordship, from the
That-
materials we have.
Yeah, so that is, because if you have not retained the judgment, how do you?
Lordship, we have everything.
Only on that point, Mr. Chaudhary, till now I am having.
No number, Milord.
Huh?
Number also.
That only 6 minutes, 6 judge.
How is it possible to even go through also?
To that point also, I have everything.
Regarding amendments with regard to prejudice, Milord, if your lordship should kindly come to page 74, para 33. That the petitioners beg to state that the entire selection process is vitiated due to non-disclosure of marks awarded in the viva proceeding. No marks, breakup, or assessment criteria were published either before or after the interview. This lack of disclosure makes the process opaque and immune from scrutiny. Transparency is the cornerstone of recruitment, and its absence renders the process arbitrary. Candidates were left unaware how merit was as such opaque violates the principles of fairness. So this is how we are prejudiced, Milord.
35.
para 33, my lord, at page 74. Para 33, page 74. Petitioner begs to state that the entire selection process is vitiated due to non-disclosure of marks awarded in a biopsy. No marks, breakup, or assessment criteria were published either before or after the interview. This lack of disclosure makes the process opaque and immune from scrutiny. Transparency is the cornerstone of public recruitment, and its absence renders the process arbitrary. Candidates were left unaware of how mark merits were assessed. Such opacity violates the principles of fairness. Honorable Supreme Court has repeatedly held that transparency is an integral facet of Article 14. Now, this is important. Non-disclosure creates a presumption of arbitrariness. The petitioners were deprived of their right to challenge their evaluation, hence the selection stands fishing. So, my lord, regarding prejudice, this is the statement. So, therefore, my lord, the other principle will not come. Now, my lord, if your lordship would kindly take the test product path of judgment for a moment, my lord. Now, if your lordship would kindly come to page 20, my lord. One of the issue was 21.4. Whether above doctrine applies with equal strictness qua the method or procedure of selection as it does qua eligibility criteria. So, my lord, whether method or procedure of selection is an aspect which needs to be made known beforehand. Now, it is in that light, lordships will kindly
What doctrine is the doctrine of Cayman's?
came on justly
Cayman says that you cannot change the
rules of the game. So, my lord, therefore, the Supreme Court also undertook an exercise whether this principle that rules of the game cannot be changed, it should be confined to only procedure or also the criteria of selection. It is in that light, if your lordship would kindly. This paragraph to Minilan, I don't know what.
paragraph 54.
Yes. Para 54. Now, if your lordship would kindly come to para 51 onwards, my lord, at page 33. What is clear from the above is that the object of any process of selection for entry into public service is to ensure that a person most suitable for the post is selected. What is suitable for one post may not be for the other. Thus, a degree of discretion is necessary to be left to the employer to devise its method, procedure to select a candidate most suitable for the post, albeit subject to overreaching principle enshrined in Article 14 and 16, as also the rule statute governing service and reservation. Thus, in our view, the appointing authority, recruiting authority, competent authority, in absence of any rules to the contrary, can devise a procedure for selection of a candidate.
Your answer is that paragraph 59.
Another example is in respect of fixing different cutoff dates for different subjects, having regard to the relative importance of the subject and the degree of relevance. These instances make it clear that this court has been lenient in letting recruitment bodies devise an appropriate procedure for successfully concluding the recruitment process, provided procedure adopted had been transparent, non-discriminatory, non-arbitrary, and having a rational nexus to the objects sought to be achieved.
55.
65 is the conclusion, Miller. Recruitment process, 55. Sorry. To elucidate the above proposition, we shall notice a few instances where procedure devised by the recruitment body has been approved by this court. In Santosh Kumar Tripathi, this court was required to consider whether the rules enabling service commission to examine, interview, select and recommend suitable candidates would include power to hold written examination. This court accepted the High Court's view that power to examination would include holding of written examination. In MP Public Service Commission, the question which arose before this court was whether in the process of shortlisting, Commission has altered or substituted the criteria or eligibility of a candidate to be considered being appointed against the post of presiding officer. It may be mentioned at the outset that wherever applications are invited for recruitment to different posts, certain basic qualification and criteria are fixed, and applicants must possess those basic qualifications and criteria before their applications can be entered into the consideration. The selection board or the committee has to decide as to what procedure is to be followed for selecting the best candidate from among the applicants. In most of the services, screening tests or written tests have been introduced to limit the number of candidates who have to be called for interview. Such screening tests or written tests have been provided in the statute or prospectus concerned which govern the selection of the candidate. But where the selection is to be made only on the basis of interview, the commission or selection board can adopt any rational procedure to fix the criteria of candidate who should be called for interview. It has been impressed by the court from time to time where selections are to be made only on the basis of interview. Then such interview must be carried out in a thorough and scientific manner in order to arrive at a fair and satisfactory evaluation of personality of the candidate. Likewise, in so-and-so, where the eligibility condition referred to a minimum 5-year experience, the selection committee was held justified in shortlisting those candidates with more than 7 years experience having regard to the last number. So, my lord, when it comes to
say that the rule of industry, which normally applies, it would be lenient while carrying out the selection. But then also the fact is that there has to be transparency.
Yes.
Fairness. Be arbitrary.
Yes. Milord, this is very important, Milord, page 34. This MP Public Service case, Navneet Kumar Poddar. It has been impressed by the court last 4 sentence, Milord, Placidum F. It has been impressed by the court from time to time that where selections are to be made only on the basis of interview, then such interview viability test must be carried out in a thorough and a scientific manner in order to arrive at a fair and satisfactory evaluation of personality of the candidate. So this, Milord, satisfaction must be derived from the records now. Since, Milord, the affidavit is silent on this, we are only, Milord, firing in the, Milord,
Or your submission would be the scope of judicial review which is there in respect to a selection carried out
solely on the basis of interview.
on the basis is much more compared to scope of judicial review when with a written test and
Yes. Therefore, Milord, it is never my submission that in case of matured, Milord, personality, interview alone can be the way. Because Supreme Court has settled it long back. In Anjar Ahmed, that is 94. When the Supreme Court had said, in fact, Milord, if
94.
Yes.
The public commission is
In fact, Milord, if your lordship should recollect the decision in Ajay Hasia and Leeladhar. In Leeladhar, Supreme Court made the distinction that Ajay Hasia was an admission to an educational institution. Therefore, a student of, Milord, tender age, their, Milord, mental faculty is not matured. Therefore, to subject them to rigorous interview is not proper. In that case, Milord, written test is more, the weightage should be given to more to written. But when it comes to mature personality, Milord, then Milord, written could also, sorry, viability also could be, but then Milord, those safeguards has to be. So, my lord, therefore, my lord, what follows from the preponderance of the view of the Supreme Court on the subject is, my lord, the when it comes to, my lord, testing a selection based solely on interview, my lord, perhaps, my lord, your lordships, area of, the supervision would be more, my lord, compared to a selection where, my lord, there is a screening or written test followed by written in Viva Voce. Because, my lord, yes. In Tridip Kumar Jingal, it was held that shortlisting is permissible on the basis of administrative instruction, provided the action is bona fide and reasonable. The contention on behalf of the state government that written examination was for shortlisting the candidate and was in the nature of elimination test has no doubt substance in it, in view of the fact that record disclosed that there were about 80 posts of medical technologists and a huge number of candidates, approximately 4,000 applied. State authorities had therefore no other option but to screen candidates by holding written examination. It was observed that no recruitment rules were framed in exercise of the power under 309, and hence no such action could be. In our opinion, however, even in the absence of statutory provision, such an action can always be taken on the basis of the administrative instruction for the purpose of elimination and shortlisting of huge number of candidates provide action is otherwise bona fide and reasonable. In any case, my lord, under Article 162, it is 65 what question? Lord, eventually at para 65, the conclusions are, we therefore answer the reference in the following terms. Recruitment process commences from issuance of the advertisement and ends with filling up the vacancies. Eligibility criteria for being placed in select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless extant rules so permit, or the advertisement which is not contrary to the extant rules so permit. Even if such a change is permissible under the extant rule or the advertisement, change would have to meet the requirement of Article 14. Decision in Manjusri lays down a good law and it is not in conflict with so and so. Recruitment bodies subject to extant rule may devise appropriate procedure for bringing recruitment process to logical end, provided the procedures so adopted is transparent, non-discriminatory, and has rational nexus to the objects of to be achieved, as are binding on the recruitment body placements in the. So, my lord, eventually what was held in Manjusri was held to be good law. Hello, that's all. Lord. So, my lord, just to conclude, to sum up my argument, my lord. Oh, yes, well, there is one more point, my lord. If your lordship would kindly come to the advertisement for a moment, my lord. Page 112, Roman 8:4. Document showing date of enrollment with a self-declaration that after enrollment, he has not left practice as advocate and has not joined any other service or profession. My lord, our allegation in the petition is quite a few number who served as, my lord, judge of the foreigners tribunal, my lord.
But my
No, my lord.
yeah, I mean,
Yes.
it is not a disqualification. If you don't file an affidavit, then it may be a case of termination, or later on if it is found out. It's not the disqualification. The eligibility, on the other hand, is mentioned out there.
No,
Out here is in this that educational qualification eligibility is mentioned. Educational and essential qualification is mentioned for this course. So here, yes, a person if he lives out there, then he has to disclose.
yes. Now, my lord, having regard to the stand of the state, my lord, we are constrained to make this point. If your lordship would kindly come to para 16 at page 159. This is the stand of the state. They have not even answered it. Para 16. That with regard to the statement made in paragraph 29 and 40 of the writ petition, the opponent denies the allegation made therein and further begs to state that all candidates were required to comply with the conditions mentioned in call letter, and the same were duly verified at the time of vivacy. It is further submitted that no candidate who failed to produce requisite documents were permitted to participate in the selection or participate or was selected. The allegation that selected candidates did not comply with mandatory requirement is based on mere assumption without any formal support.
But unless it is the case of disqualification,
Miller.
it is not a case of disqualification. If I am doing a job, my requirement is for becoming a public prosecutor is 8 years of practice. But I have to then fulfill the test as per 19.2, that these are the tests. But it is not as a disqualification, but I have to mention that if I am doing some other job, I have to categorically mention that these are the jobs which I have done. And if I don't mention it, later on, if I am appointed also, I may be terminated, which is.
And on that only, Miller, since a consequence has been provided, so this clause has to be constituted as mandatory. Because the clause
No,
itself
no,
says,
is it your submission
yes,
that this particular verification affidavit was not submitted? This is not your case.
no, the affidavit part is not there, but to our best of our knowledge, these are the person who served as a member of the
No,
foreign
So, but that is not a disqualification. That
No,
is
no,
my case.
Understood, my lord. But what is the meaning of this clause 8 at page 112?
So therefore, the court says that if you are working in some other place, you have to categorically mention it. If you don't mention it later on, if we come to know, you will be terminated or chucked out.
No, kindly see, my lord.
Yes.
Please come to page 109 first.
Yeah.
my lord. Essential qualification must have practiced as a regular advocate for not less than 8 years, including practice before basically on the criminal side.
Yes. So he has to have 8 years. Practice on basically on the
Regular
criminals.
practice, if he is a regular practitioner, how can he become a judge of the foreign tribunal?
He may leave one fine morning, taking into account what has happened out here. He may have left it. The criminal practice was not so good, so he must have left it. But whether he has 8 years of practice or not, that is the essential qualification.
No, true,
Unless
sir.
it says
No, it
that-
says, and has not joined. And you see page 112. Document showing date of enrollment with self-declaration that after enrollment, she has not left practice as advocate and has not joined any other service business, professional business.
yes. So if he is
In
regularly,
case facts, such claim comes to fore,
Hmm.
can be rejected and may even lead to termination. If
Absolutely.
rejected after joining this.
so
service.
therefore, this is not a disqualification. This may be a case by which he may be very well, that might be a consideration which may come into the mind of the authorities not to, he's already having a job, why should we? But that is not a disqualification.
No, Milord, in the affidavit filed by them, how they have dealt with, please have a look at that.
I've read it at paragraph 16.
No, page 15. Milord.
Yeah.
Milord, we have specifically mentioned the names also. Now, this is in basically 23. 22 and 23. Our allegation represents that with regard to the statements made in paragraph 21, 22, 20, etc. The deponent begs to state that it is a matter of record and further begs to state that clause in advertisement dated provides for a candidate to submit a self-declaration In the event of detection of any false declaration submitted by the candidate, her case shall be rejected and even lead to termination from service. Well, this is what the clause says. They have not said, they have not given their stand, my lord.
Now they are saying in the event of detection of any false alia in man, his or her candidate shall be terminated. If
So
he
it
gives a false, but that is, therefore my question is.
No, no,
it cannot be.
it's not a
If it
disqualification.
is not a disqualification, he can very well participate. Having his qualification requires 8 years.
8 years regular service. Advocate. And my lord, these are my humble submission, my lord.
You'll reply after
Yes.
what the application.
Yes, yes.
Gone through that slide, the great lordship, and I feel 3 points we'd like to bring on record. One is that the contention they have raised that 6 or 7 minutes is not sufficient. What
I am reading.
I-
Their main contention is
Yeah.
you are not keeping the records.
that also I have replied straight, but that record we cannot manufacture now to give it. Minutes of all the interview proceedings are there. Exact assessment, inter-se assessment are also there. Everything is there. So I'd like to bring a chart. What are the categories? That is number one. Number two, regarding the total number of minutes given. The interview process continued for about a year. Every day during that phases, we called about 20 candidates. And out of 20, about 30-40% were absent. Later on, we increased it to 25 also. So sufficient time was given. 6 and 7 minutes in my humble submission is more than sufficient. Because in our admit card, they are saying that whatever the methodology was devised by this board, they have taken a decision that they will ask questions on the pleadings, on the petitions, on the appeals, on the judgments they have done during the course of practice. If lordship is pleased to look at that. So they are saying that it was not notified. It was notified. If lordship is pleased to come to two admit cards. 116. 116. Page 116. Serial number 5. This is the admit card. Every candidate shall require to produce before the selection board at least one copy of any application, petition, appeal, etc. drafted by the candidate himself, herself, and filed and registered before the court of law in any criminal proceedings. That is number one. Number two, every candidate shall be required to produce before the selection board 4 copies of any order, judgment passed by a court of law in any criminal proceedings in which the candidate himself, herself appeared, conducted, and argued the matter. What more is required? Whole question paper is given to them.
And you see this. No, Mr. Advocate General, this is the document which they gave us. This is important because here, apart from what is mentioned in the admit card, this was a notice to all candidates to appear on that. Let's see in the last portion. What are the documents to be?
Instructions to the candidate.
Ah,
Lordship want me to read this?
the last one.
In
No.
case a candidate.
No, before that,
The
before
call
that.
letter,
Before that.
any
No.
Candidate found
The earlier page, the last
the
one.
whole one, 5 and 6. Every candidate shall be required to produce before the selection board at least one copy of any applications, petitions, appeal drafted by the candidate themselves and filed and registered before a court of law in any criminal proceedings.
So
6,
this is what it is there even in the notice board, which
the
is.
notice board as well as in the admit card. So whatever questions the interview board will ask, it will round around those materials. So if we give them 20 minutes and tell them to write a petition on bail application, for example, that will consume 15 minutes. Then they will be asked questions on that bail application. This interview board have done a smart job. Ask them to give your petitions which you have filed before any criminal court, any judgment. From the judgment, it can be very well deduced that whether he appeared or he is one of the advocates out of a group of advocates of 7 advocates, whether he argued or not, whether his name is there, is recorded as a heard,
so and so. The judges and the other persons who are part of the selection board, they are well qualified, they are expert in that field. So for that, 6 or 7 minutes is more than sufficient in my humble submission. They could have wasted time by allowing them to draft a petition, whether it is a criminal revision petition, that will consume 2 hours. So this is the way how things can be done in a smart manner. And this interview process continued for a year. That's why in the additional affidavit, I will bring on record how many days the interview board set. I have done a very
The
honest
interview,
job because they did not want to deprive any of the candidates, and then that will be revealed from the records.
interview board set from 21/10/2024 to April 2025, 6 months.
That's why how many phases they have. And there are 3 boards.
Therefore, this is which document which they have given.
Yes, that itself
Is
will be important.
is it pertaining to one board or many?
All, it's a general. And Lordship will kindly come to page 120 also, next page.
Okay.
For different categories, additional.
Mr. Advocate General, this document you kindly bring it on record because
Yes,
this
I'll
is
bring
a
it on.
document which is there.
Because his admit card, they themselves, they have not placed it before during the hearing, but this admit card is sufficient. Because without that admit card, they cannot enter and be a part of the interview board. Strictly speaking, but there is leniency in that also. If somebody is not received the admit card, they are also allowed to appear. The
But
interview board,
Mr. Chaudhary, you say
yes,
that the Vivavosa exam started on 21/10
One second.
while mentioning the list
Yes,
of
yes,
dates.
yes, yes.
But on this very document say, Vivavosa
No, you
had started on 17/8/2020. This document which you have given to me.
Maybe, my lord, maybe it started, but we are also having a document to show that it was on 21/10/20.
Now, this is the very document
Ah.
which will be says that 17/8.
Some boards were also postponed, my lord.
This is
Yeah,
a
but
different thing
that-
that started
that-
because this is
that
a.
that is not very important. We're not finding fault in that.
2010. Okay.
so my instruction, almost a year, it continued. So all these things I would like to bring on record. And also what are the categories of marking, because 30 marks category is indicated in the modalities of the minutes.
Hmm.
Rest, in what category, how many marks were given in appropriate subjects, Lordship, that also I like to place. And also they have raised the issue of non-submission of records. Comparative statements.
Does any of the petitioners belong to any of the reserve categories? No.
But I think, yes, my lord, for example, Devojani is an OBC, my lord.
So she'll be in OBC. And others will be regular, normal.
And one very important and very relevant proposition is that we have advertised for 299 and we could point about 241. In reserve categories also there are two candidates.
Under the
So, due to lack of skill, the interview board did not allow, even if there are vacancies. So I'll bring these points also on record, Lordship. Lordship will kindly give me 1 day. By tomorrow afternoon, I'll file the affidavit. If Lordship is to take up day after tomorrow, I will be ready. We'll give an advance copy tomorrow afternoon to the other side.
You give that. And you also, and we have it on next Tuesday. Whatever may be. The thing is, I also want the marks of the petitioner, the 5.
That is what I'll place.
No, only because I don't require the marks of all 7,000. It's not required. Give the marks of these 4 petitioners and the marks which have been of
Last
these two,
candidate
the
in this category.
in his category, because therefore I ask as to who is there,
Got
anybody is an OBC. Then the petitioner would also know what are the marks
Got it.
available. Put it on that affidavit.
Instead of Tuesday, it will be Thursday, my lord.
Thursday is the last day, no?
No.
Yes.
Friday, my lord. Friday.
Thursday, is my last.
Or on Wednesday, my lord.
Okay. But it would be.
Tuesday I'm tied up.
No, can you
Or
file
it
it
can-
by tomorrow?
Yes, Lord, so we'll file it.
Okay, then let's hear the
Okay,
advocate
let's
general.
Tuesday, my lord, we'll sing.
No, let's
Day after
hear the
tomorrow.
advocate general on Tuesday,
Yes.
tomorrow, day after.
Yes.
And thereafter, if need be, we'll hear you.
On another day.
On another day.
My lord, that will be.
Because I want to keep the momentum, Lordship is hearing it. So
that
there's a
is-
gap, then again there will be.
Heard Mr. Kane Chaudhary, the learned senior counsel appearing, assisted by so-and-so appearing on behalf of the petitioner. Petition. I've also, the Mr. Kane Chaudhary had completed his argument. Reserving his right to reply. He's like the learned Advocate General Assam is being assisted by Mr. Dina. He submits that though the petitioners were granted the liberty to file the reply to the affidavit in opposition filed with respondent number 2 on or before 8/6/2026, the petitioner have filed the affidavit in reply only
Yes, sir.
on
15 minutes.
15th of June 2026, wherein, apart from retreating and reaffirming the statements which have been made in the petition, certain new additional points have been raised. And the state would be prejudiced without being granted an opportunity to rebut to the allegations made in certain paragraphs. He submits that the said affidavit will be filed by tomorrow, and the matter can be taken up on the next date. A matter can be taken up on Thursday. The date to be. Taking into account the fact, this matter again on Thursday at the top of the list. Alia. You bring this up. Where is Miss RDB? Yes, because of you, Mr. RC Boswell was speaking. Yes. Now the question is RDB is this. Take on question. Yes. RDB, tell me one thing. The gem had put a say that his license was not had expired. Whereas his license was not expired. That is the short one. So apparently the licensing authority is the state, not the center. The licensing authority has categorically said that the license is valid. So on account of the GEM's mistake, why the petitioner? That's the simple. Why did the petitioner suffer?
Lordship, I have for 1 to 4, and in respect of uploading of that,
No. You see, game works out here. You have the game to do.
Lordship,
Now, yes, they may have made a mistake.
Documents are not uploaded, Lordship. These documents are not uploaded, and without Lordship, these documents, this case cannot be considered. This one's, Lordship, these documents are not uploaded in the GEMS. No, Lordship. The entire bid documents was not uploaded. It was not allowed by the GEMS, Lordship.
Where? It only says that the entire document was not uploaded.
It was,
It was uploaded only where the license was not uploaded, saying that it has expired, then. Then the
only
point,
three bidders' names were, Lordship, appeared in the GEMS portal, Lordship, and we have received the bid documents of only these three bidders, Lordship, not the petitioners.
Understood. Now, if Jem had made a mistake,
Yes, Lordship.
Jem is your authority. You have delegated, you should have done it by yourself. You have taken the benefit of the e-marketplace. Government e-marketplace is Jem. So you have asked the government e-marketplace and you have used their facilities out there for floating your tender. In pursuance to that, he has done it. If Jem has made a mistake, it's yet your expense. He has thereupon submitted a document to you that look here, my representation to you and saying that look here, my license is otherwise valid. Where is it say that the document has not been uploaded? The entire thing? Where do you say? What is the name of the petitioner? Riponjit Sharma. Riponjit Sharma. Where is it? Huh?
Yes, it is of our.
Yes.
Lordship.
Where?
Second line. Lordship. Further, the approval of settle by the GEM authority and such other matters come under the exclusive domain of the GEM portal. And respondent number 4 is not even remotely connected or concerned with these matters. The GEM portal has the sole authority to allow or disallow uploading of bid documents by a bidder, and respondent number 4 has no role in it. It is only when a bidder successfully uploads his bid documents only when the earmarks time for opening of technical bid arrives, then only the GEM portal allows respondent number 4 to open the technical bid. Respondent number 4 has a very specified and limited access to the GEM portal, that is only to float needs, to fix date and time for submission of bids, to fix date and time for opening of technical bids and financial bids, etc. Therefore, the question of rejection of petitioner's application by respondent number 4 on the ground that is uploaded, the certificate had expired is an impossibility.
Now, this particular, so here you therefore only put into that aspect. The video has not been uploaded is not the question.
Say, license.
But the license is actually valid.
Well, Lordship, as per their affidavit, it is annexed, Lordship, that it was not.
Now, unless you are contradicting from yourself that the license is not valid, isn't it the mistake committed by your authorities?
Lordship, unless it is uploaded in the GEM, we cannot.
That's a different thing. I am not on that. Are you denying to the fact that the petitioner's bid, the license is valid or expired or not? What is your statement? What is your stand? We have seen into the search, where the petitioner has specifically alleged in the petition that his license was valid. What is your stand?
Lordship, ourselves, since it is not accepted by the GEM, so have taken to do that.
Now let us see the terms and conditions of GEM. Where is it? Who is paying for GEM?
DP Bora, Lordship. DP Bora.
Where is it? Every time we find out another. Let us see what is GEM has filed an affidavit.
It is not served on us, Lordship.
GEM is a party.
Yes, Lordship.
GEM is made a party, my lord, as per direction of this honorable court, my lord. They have submitted their opposition to paragraph 7. Paragraph 7 of their
Neither in behalf or respondent against the petition in the filed by what does it say? So, you are already raised, sir, at paragraph 4 of the affidavit filed by respondent number 5. Page 209.
And as for their affidavit in reply also lodged at page 184, as per the GEMS inform them that certificate would not be validated the issuing authority database oblique website. That is why your license is continued. Not accepted.
Now, yeah, this has been done by rights. Is rights a party?
No, that's
Now, you see, the affidavit filed by Jem says that we don't do rejecting. It is done at the behest of rights. And you see the paragraph number 5 of the affidavit.
yes, no. Number 5. But then, Melo, that's a new issue they are creating just to confuse the situation, Melo. It was not in a picture, Melo.
Why will they do it? They need to correct. They do. So your document was rejected by rights. Kindly see therefore,
Then,
paragraph 5, 6.
that is, yeah, but then in the JAM has already admitted that.
No, Jem categorically says that we did it because that has been rightly done so.
Melo, on 1st of May, Melo.
No, kindly see paragraph 13 of that affidavit. Rights did not approve your catalog, your license.
But then
Because of your
later
license.
on, Melo,
Huh?
later on, the development that has taken place, so JAM has filed their affidavit, Melo. They have admitted on 1st of May 2025, the law manager has written to the petitioner that you provide all the documents that you have provided earlier. And on that basis, on 8th of May, we have already provided through email system. And after that, on Miller,
8th of May 2026.
yeah, 2025.
Then
Then on 25th of May 2025, JAM has considered all the documents and they have approved the entire process of.
understood. But they have filed an affidavit saying that why it was not uploaded at that point of time, it was said to be expired because rights says so. This is what
No,
is
my
the stand.
No, sir. Much,
In response to the tender document.
Use your mic, madam.
In response to the tender document, as per the rule, my lord, we have annexed all the required documents, we were uploaded. But unfortunately, only our drug license that could not be uploaded in the GEM portal. And in the GEM portal, your lordship may kindly see annexer F. It is written
Page,
that page 56 of our writ petition.
yes.
The uploaded certificate is expired. Kindly upload the renewed certificate. Thereafter, again, we uploaded that certificate. Your lordship may kindly see at page 57.
This is time.
Page 57 of our writ petition. In the lower portion, again, they have, it is written that certificate could not be validated through the issuing authority database.
Wait.
Bottom question, madam.
Huh?
Page 57. Continuation of annexer 7, next page, my lord, 57 at the bottom.
Certificate could not be validated
To be validated.
through the issuing authority database website.
Right.
Yes.
That, then thereafter we approached the central CGSE for extending time for uploading the uploading our all drug license. But in the meantime, what happened? They have accepted the other bidders. So we could not enter in the process because this drug license could not be uploaded, was not accepted by GEN. Thereafter, we again approached them for extending the time for submission.
No. But fact remains,
Yes,
they had no role. They also admit, Zem also admit.
hello.
As regards the aspect, your drug license was looked into when your catalog is to be approved.
Yes,
You need a drug license.
Yes.
Now that drug license was rejected by rights.
by GEN,
No, by rights.
yes, my
If
lord.
you see the affidavit, it categorically says that it has been done. You see category C. Paragraph 5 of the affidavit filed by Jim. The petitioner in the month of November applied for the service category local chemist empanelment service. It is pertinent to mention that for this service, pursuant to uploading the service catalog on the GEM portal, the application of the service goes through a scrutiny process via the respondent number 5's vendor verification agency, that is Rights Limited. It is only after due verification approval by Rights that the service catalog of a service provider gets published in the GEM portal in the relevant service. It is noted that a service provider can participate in the bidding once the service catalog of AI is published here. In the present case, as per the established process, the verification of the service so and so uploaded by the petitioner was done through Rights. However, Rights rejected the application of the petitioner because of the reasons stated here below. It is pertinent to mention that the petitioner's drug license certificate could not be verified from the issuing authority database website. Moreover, the license renewal, license retention letter issued by the competent authority in favor of AR from the period of AR was also not submitted. Thus, in view of the aforementioned, the application of the petitioner to upload the service here was rejected. 2 copies of the documents uploaded there along with the application to upload the AR annexer CA1. Let us see CA1. CA1, yes. So and so to approve the catalog there, so our license was renewed from time to time. Then from last time it was renewed till Iman. In this context, I would like to inform you that we have applied for the approval of the technology service going on. Concerned authority. However, the catalog has been rejected by GEM authority, citing the reason certificate could not be validated to authority. Simple. In this regard, I would like to draw your kind attention to the metaphysics we took by the drug controller Assam manually in 2007. And the process is still prevalent in Assam. On contract with the authority concerned in this regard, it is found that the person is still process is still necessary and they have not issued online license. However, I have applied for a press license today. Is to be done after that today on demand, after left with no other option. They that is for improved for demand. We are being requested to look into the matter of consider according to our catalog as one of the measures so that it does not exclude deprive the natural justice of doing so. The treatment of online application. Who appeals for the medical health? In health authority, the state has.
No, no, no.
It help should have been there because they issued a license, license. The application. Okay, 6/11/2001. PN certificate. Now, this certificate at page 229
Yes.
is a certificate issued on 2024. And drug license unless you are suspended or license will remain valid for 50 years. Proof of illegal. Where is your renewal certificate?
My lord, our additional. Additional fee dated 28/11/2024. As for this on the report direction, we have submitted all our certificates which we have uploaded in the GEN. Drug license, then non-conviction certificate, pharmacist registration book, all these are required documents which have to be submitted by the bidder. The all were accepted, only our drug license.
So you enclose only this certificate.
We have uploaded all the certificates, only the drug license that was not accepted by the GEN. Saying that it has expired. At page 56 of our revision, it has.
No. My question is your license not required to be renewed?
No, it has been renewed till valid up till.
How is it renewed? Isn't it renewed in a particular form?
Yes,
Where is that renewal? Up to 31/3/2000, 31/12/2026.
renewal cert, Two thousand twenty-six, my lord.
Where is the renewal form?
My lord, at page 74.
Eight?
Page 74 of our
No,
edition.
no. This is a certificate.
Yes,
A renewal has to be there in form 21, 20 and 21. Where is that?
yes, 21.
A drugs and cosmetics. Let me come back at two. The renewal has to be in form 20 and 21. No. Therefore, you see that certificate down below it says this is being given at your request. But a certificate has to be valid as per the form.
In connection to the issue your document, in a way that you were given time to file an affidavit exactly on that form.
Let's see the rules. How the renewal of license.
People also allows me one of them, to file the affidavit only on that point, to satisfy your lordship of that particular point. Is my humble prayer.
Yes, Mr. Bora. Tell me one thing. The license is there perpetually unless it is not cancelled. Why did your authority, your vendor, hold it as expired? No, your vendor did it. No. My question is, can a license which is issued under Form 20 and Form 21, this is done under Rule 61, expire? No, where's the question? Where's the question of renewal? Unless you see, the concept of renewal is not there. It's for the drugs and drug rules 1945. Then why did your vendor did it? Why did, kindly come to your paragraph. Kindly see your paragraph. Why did you do it? Kindly see paragraph 5. The application of the alia goes through the scrutiny of the so and so. It is only after due verification and approval by rights that the service catalog is so and so. Now 6. However, rights rejected the application because of the reasons stated below. It is pertinent to mention the petitioner drug license certificate could not be verified from the issuing authority database. Moreover, the license renewal retention letter issued by competent authority in favor from so-and-so to so-and-so was not submitted by the petitioner in the uploaded so-and-so. Now, whether there is a concept of a license renewal, no. My question is whether there is a concept of renewal of a license. No, that is what I am saying. No, kindly see the Form 20. Form 20, the license was issued. License to sell, stock, or exhibit or offer for sale for distribute drugs by retailers other than so and so. The license, unless sooner suspended or cancelled, shall remain valid perpetually. However, the compliance with the conditions of the license and provisions shall be assessed not less than once in 3 years or needed as per the risk approach. That's a different aspect. But it will remain perpetually. Now see Rule 21, Form 21. Form 21 also says the same thing. The license, unless sooner suspended or cancelled, shall remain valid perpetually. Then where did you bring the concept of a renewal or license retention? Did you ask that in your tender? My question is this: where is your tender?
After in Form 20 and 21, license was granted only for a specific time period. Also.
Huh?
License was granted only for a specific time period. That license shall be enforced from 17/3/2007 to 3/12/2011. Therefore, Lordship, it was renewed in time to time.
How is it possible this license can be given like this?
It is in a format, Lordship.
This is not a. No, this license format is wrong. It is so because the license 61(2). Let us
It
see
is
Rule
17.
61(2). Does it say so? Unless it is a new thing which has come in. 61(2). A license to sell stock so and so drugs specified in C and so excluding so and so by retail or restricted license or wholesale shall be issued in Form 21. Form 21A or Form 21B as the case may be. Provided license shall not be granted for drugs so and so. Now, this is for C drug. Now, this is done under C. See the rules 21. 21, Form 21. 21 does not have that format. Oh, this was earlier. Okay. Now, Mr. Gorpatra, tell me, did you get this license thereupon renewed? This at page 73.
Yes.
Did you get another license thereafter?
Now, after the specific period is over, there is a process for issuing the press license.
No, there cannot be. There is no concept of that.
Yes.
You see, earlier it was there.
Yes.
See, no, from 2017, there is no concept. Prior to 2017, this format was there.
Yes.
My question is, this was from this to this. Now, after that, Did you get any license?
Yes, madam.
Therefore, they say in this certificate which will be given at page 74.
It is not a certificate.
No, no, in the certificate, no, actually they should have given you it in this form. They have not given it, that's a different thing. But this certificate therefore says this. There's an amendment to this form.
Yes. Your listing is that.
Earlier, the form stipulated like this.
Yes, after 2017, the system.
It has changed. And you have not been issued a fresh license.
Yes,
It's not a question of renewal. It's a question of getting a fresh license in the particular format.
it will continue in perpetuity manner unless it is suspended or.
Yes, that is why it is safe. Because there is no concept of this, the format has changed. Now, there is no amendment to Rule 61 in the year 2017. Only the form has been changed.
Only problem.
The form has been changed in view of this 2017 form has been changed in view of when we see this particular page 74.
Yes.
Shall be valid perpetually for above as per government notification dated so and so. So therefore, the form had changed. So it was your mistake. Because the license, the question of renewal of a license does not arise. It is fact that it was the very thing which you have taken was absolutely not necessary. Now, what is the remedy we can do? I did not get it. I am saying that we have not been able to assess it because of the fact that you did not proceed with it. On the basis of your vendor. Your vendor made the mistake. Now what is to be done? Find it out because what you have done, both of you have done. He has applied some interference with his vendor.
It is not available as per, lordship, their decline lordship, it is not in the database.
You floated a thing. Who's there? Then use the yardstick for the purpose of not accepting him when the question of our license being expired does not arise unless it is cancelled. License being expired is foreign. They made the mistake. Now, how do you empanel him?
Lordship, his bid was not uploaded, lordship, how can we evaluate his bid?
Your mistake, both of your mistake.
No,
Yes, when we do not import cost upon, import the
even lordship,
cost upon you,
lord-
10 lakhs.
lordship, it is already,
To empanel him.
lordship, pursuant to the bid notification, is already, lordship, what new Burman.
So we cancel that empanelment.
Lordship, their prayer may be, there is no prayer for lordship, challenging the rejection of their bid or not being able to upload their bid, lordship, on any other ground. Their prayer may be,
Tender process is over.
over, lordship. In 2024 itself, and as per the,
No, Milo. Our extended period was up to 28/5/2025. I unattended misleading this announcement. That's why I'm just pointing it out. We have got the document. On first of April, Milan, because this honorable court was misled that the service is not available, but then we were allowed up to 28th of May 2024.
What is ALC?
Authorized local.
Authorized local chemist. Since there was lordship stay order operating in this case, lordship, there was, therefore, he was allowed to continue.
Now also you are continuing.
No,
No,
No.
up to 28th of May 2025.
after vacating of the stay order, lordship, the new, chemist has been employed.
Now, once Jem uploads it, then you look into it. Without disturbing the existing empanelment, can we direct you to look into it because it was a fault on the part of your Jem? They have given the representation.
Lordship, this empanelment is, for 3 years.
know.
This empanelment is, for 3 years, lordship.
So what? For remaining period, he will be there. For that entire period.
Because, lordship, three, chemists were, the bid were, lordship, in the, jam portal, lordship. And among them, doctor, after taking.
No, no, no.
New Burman has.
Madam, you have to understand, this is not a case of a grant of a contract, it's a case of an empanelment.
Empanelment.
Empanelment, what? When a person is empaneled, he is put into the particular black block. Then tomorrow, when you want those particular medicines, you float another tender for arriving at a particular rate. On the basis of the empanelment, he has a right to quote his rate for tracking. This is the only right you give him. Where is your tender? This appears to be the basis on which you do it. How do you go for an empanelment? Where is the tender for the tender document has not been properly? Where is the tender?
129 of our, affidavit, lordship, is 129. Here is.
Here, kindly come to page 136. This is the clause.
Yeah.
Now the question of renewal is foreign.
Should be valid. On the date of submission of bid.
Huh?
It should be valid on the date of submission of bid.
Understood. The license was always there. And that particular certificate has also been given that it is valid till 31/12. I don't fail to understand how is it valid till 31/12/2026, where the concept of a license being valid or not valid does not arise. This is the law.
There is also a renewal provision lordship, the next one lordship. In case he applied for a renewal lordship.
Huh?
There is also a provision for renewal. Next one lordship. B.
Now, that is
136.
what my therefore question is, where is the concept of renewal of a drug license? When the concept is foreign. You have to read into the rules. Kindly see these licenses. See all these licenses, see how in which form it is to be given. They didn't remedy, kindly see this. See the forms. Assessment is different. Assessment has nothing to do with clause 6. Now his commercial bid has not been opened.
That's not even uploaded in GEM.
That's good. His bid was uploaded.
Uploaded lordship.
No,
The GEM.
again you are saying. His bid was uploaded. His only certificate was not accepted. That is what you have also stated in your affidavit. The bid was uploaded, but his certificate was not accepted, taking into account that particular certificate has been expired. That is the basis of, as per the survey.
Lordship, we have received the bid of only 3 bidders lordship in the GEM portal lordship, not the petitioner. Remedy lordship already.
No, he will be impaneled only till 31/12, the next day. This 2024 onwards, when did the empanelment start?
That was of 2024 lordship.
That's true, but that will completed when?
2006. I think 40 years ago. 129. Years.
But it
But there was
started
a-
on
but there was
29th
a-
of May. Up to 28/5, we were there when supplying. Then the next allotment is made to the other party on 29th of May, 2025.
No, no, period, you do one thing. We hold them to be technically competent on the basis of the drug license and ask you to evaluate and consider whatever the bid which is there.
Is already, chemist has been empaneled lordship. In that case, the third party right to have also been,
Can there be only one bidder?
yes, lordship. In, two and three,
No, no, how many you are going to empanel?
only one empaneled lordship, new Gormont store, Gormont
Let us see what is the scope of the contract.
Lordship, page 166, this is the list, Lordship, which has been, uploaded from GEM, Lordship. Only three is not clear, only three details. One 66.
The scope of the contract is either kind of empanelment. Empanelment what? Empanelment. Can there be only one empanelment? Have you fixed how many?
After details, Lordship.
Central government is providing comprehensive medical services to so and so and so. As part of the beneficiaries are entitled to medical consultation and treatment from CDC wellness center aspires to ensure timely supply of medicine. These objectives additional on behalf of the invite online bid. The government of India parted from reputed chemist shops located within the same that preparing the principal expenses for supply of allopathic medicine. The names of the CDS units and their locations in the students were not with the details of performance of students. Empaneled chemist is to be known as the authorized local chemist will supply the allopathic medicines at a uniform rate of discount and MRP. How many empaneled though?
As per my instruction, Lordship, one empanel.
Oh.
And 157, there is two wellness center, Narangi and, wellness center, Panguja. 157, please, number.
One 157 is for
The wellness center, against.
There are two wellness centers. It
wellness
is specified there.
and how many ALC?
Earlier, Lordship, Priscilla was running this, two wellness center, now Lordship, almost medical has been.
Huh?
Panel against this two wellness center.
So somebody else have been appointed.
Yes, Lordship.
How could? If I allow them to consider
Yes,
now
sir.
your case, it will be difficult.
Yeah.
Without they being parties.
No, no, they are parties, Milan.
No, no.
No,
Gormont-
those persons who have been empaneled,
Because one, we have filed the,
that's a different thing. But Mr. Boboto, how do I interfere now? If you see, normally empanelment, what happens? When there is an empanelment out there, that amongst them, the service and all these things happen. But here the concept is different. He's empaneled out there. And you see this scope of the area. We do one thing, you obtain instruction as to how many how many persons have been empaneled on the basis of how many, because this notice inviting tender is not clear. How many persons will be empaneled? But one place is the empaneled chemist is to be known as so and so. It means that it is a singular form.
141 also, Lord Chair, it is in the tender document, it is written there. Name and address of CGHS Wellness Center in which required empanelment of authorized local companies. 141, Lord Chair.
Name of address of wellness center in which embarrassment of
Name and
wellness center so and Panbaza mentioned in annexure B. So these are the two, and two have been appointed.
already, Lord Chair.
I'll help you. It is wrong, so you may ask for damages against them. Okay.
Malad, if it
Have a-
it is not
but
you on our part.
You have to act diligent, active. You knew it, you gotta stay out here, you should have seen to it, immediately made those people a party, filed another separated petition challenging their empanelment. Without them being parties, how do I?
Malad,
Okay, Dr. R.C. The council assisted by so and so appearing on behalf. Which RDB appears on behalf of the respondent number 1 to 4. The so and so appears for respondent number 5. The petitioner herein is agreed now the petitioner herein has filed the instant writ petition seeking a direction to extend the time of the technical bid of the open e-tender F.NO dot CMS oblique CGHS dash GHY oblique ALC oblique 2024 dash 27 dated 4/10/2024. And further allow the petitioner to participate in the said tender process issued by the additional director of CGHS. At the outset, it is relevant to take note of that the petitioner have not challenged the action on the part of the respondent authorities, more particularly the respondent number 5, in not accepting the bid of the petitioner on account of submission of an expired drug license, or the petitioner have also not challenged the empanelment granted to two entities pursuant to the said tender process. Next. The records reveal that on 4/10/2024, an online bid was online bids were invited from reputed local chemists with shops located in Gauhati city within municipality area for supply of allopathic medicines to CGHS wellness centers. Of Gauhati under the Ministry of Health and Family Welfare, Government of India. The said online bid contains various terms and conditions as well as various terms and conditions. The said online bid categorically mentioned the schedule for submission of the bid as well as the last date and time for uploading of the bid. It was further mentioned that the technical bids would be opened on 1/11/2024. The petitioner being interested submitted its bid submitted his bid as proprietor of MS Kaziranga Medicos. However, at the stage of processing the bids to be sent to the respondent numbers 1 to 4, the respondent number 5 rejected the petitioner's bid on the ground that the uploaded certificate, uploaded drug licenses had expired. Under such circumstances, the bid the bid so submitted by the petitioner was not forwarded to the respondent numbers 1 to 4 by the respondent number 5.
Uploaded in the GEM portal.
Uploaded in the GEM portal, submitted and uploaded was not forwarded to the respondent numbers 1 to 4. It is very pertinent to mention that there is no challenge to the said action on the part of the respondent number 5 in rejecting the uploaded bid of the petitioner.
We have challenged it.
No, you are not challenging the requisition.
It is there.
No, there is nothing else. The records further reveal that on the other hand, the petitioner on coming to learn that the petitioner's bid have uploaded bid have not been processed on account of submission of an unexpired certificate, submitted a representation on 6/11/2024 to the respondent number 5 to approve the catalog of local chemist empanelment service. In the said representation, the petitioner categorically mentioned that the petitioner's catalog have been rejected by the GEM authority, citing the reason I have not challenged that. It is further relevant to take note of that subsequent thereto, another documented page, another communication was issued by the respondent number 5 mentioning about the service catalog which have been rejected pertaining to the local empanelment service. Insofar as the petitioner's request for local empanelment service was concerned, it was mentioned that the certificate of the petitioner could not be validated through the issuing authority database website. In pursuance thereto, on 6/11/2024, the petitioner submitted a representation to the respondent number 5, stating inter alia that the licenses, etc., were issued by the drug controller Assam manually in 2007, which is prevalent in this, which was still prevalent in Assam. And there was no license issued online till date. It was further mentioned that the petitioner had applied for a fresh license online in the Ease of Doing Business website of Government of Assam on 6/11/2024. And therefore, requested the respondent number 5 to consider approval of the petitioner's catalog as a one-time measure so that the petitioner may get, so that the petitioner may not be deprived of natural justice with regard to participation in the bidding process within the last date dated 8/11/2024. The record reveals that pursuant thereto, the petitioner approached this court by filing the present writ petition on 21/11/2024. The learned court made bench of this court by the order dated 6/12/2024 passed an order directing maintenance of status quo till the next day. The records further revealed that on 13/12/2024, notice was issued and the status quo order was extended to the next day. The record further reveals that by the detailed order dated 1/4/2025, the learned court bench of this court had vacated the interim order which was passed of maintenance of status quo. The court also finds it relevant to take note of that an affidavit in opposition was filed by the respondent on 17/12/2024. In the said affidavit in opposition, the respondents have categorically mentioned that the respondent number 4 had not rejected the petitioner's application for extension of the last date for submission of the brief. On the ground that the petitioner's uploaded certificate had expired. It was mentioned that the rejection of the petitioner's request for extension were rejected was on account of the e-tender notice dated 18/9/2024, which was cancelled due to error in figures and years, and republication was done on 4/10/2024, resulting in an extension of 10 days in the tender process. Secondly, there was a standing instruction from the Ministry of Health and Family Welfare to shift from the earlier Central Public Procurement System to the later GEM system for appointment of ALCs. Therefore, respondent number 4 was under severe pressure to ensure completion of the tender process before the targeted date dated 16/12/2024. Thirdly, granting extension of the last date for submission of the bid on the basis of the application of the petitioner might open up a floodgate for numerous other such applications from other aspiring bidders, causing enormous chaos and disorder, leading to a paralytic situation of the tendering process. And finally, on 30/10/2024 itself, the respondent number 4 had extended the last date for submission of the bid by 7 days from 1/11/2024 to 8/11/2024 due to the collision of the earlier declared last date, bracket, that is 1/11/2024, with local holiday declared by the government of Assam. In addition to that, it is also mentioned that the respondent number 4 had no consideration in mind with regard to the petitioner's expired certificate, etc., while rejecting his application dated 30/11/2024. Inasmuch as the approval of the catalog by the GEM authority and such other matters comes under the exclusive domain of the GEM portal, and the respondent number 4 is not even remotely connected or concerned with these matters. Further to that, it was mentioned that the GEM portal had the sole authority to allow or disallow uploading of the bid document by the bidder, and the respondent number 4 had no role. It is only when the bidder successfully uploads his bid documents and only when earmarked time for opening of the technical bid arrives, then only the GEM portal allows the respondent number 4 to open the technical bid. Under such circumstances, it was mentioned that a question of the rejection of the petitioner's application by the respondent number 4 on the ground that his uploaded certificate had expired is misconceived. The affidavit of the GEM portal of respondent number 5 is of relevance, taking into account the stand which was taken by the respondent numbers 1 to 4. In the affidavit filed by the respondent number 5, it is mentioned that the respondent number 5 is a national public procurement portal. That's an end-to-end online market for central and state government ministries of the departments, central and state public sector undertakings, CPSUs and SPSUs, autonomous institutions and local bodies for procurements of goods and services. The same portal is owned and managed by GEM, GEM capital SPV, which is a Section 8 non-profit company registered under the Companies Act 2013. Insofar as the dispute in question, it was categorically mentioned at paragraph number 5 of the said affidavit that the petitioner in the month of November 2024 applied for the service category local chemist empanelment service. For the purpose of this, insofar as this service category was concerned, Pursuant to the uploading the service catalog on the GEM portal, the application of the service provider goes through a scrutiny process via the respondent number 5's vendor verification agency, that is RITES Limited, RITES, all caps, Limited. It is only after due verification and approval by RITES that the service catalog of a service provider gets published on the GEM portal in the relevant service category. Further to that, it was mentioned that a service provider can participate in the bidding process once the service catalog of the service provider is published in the relevant category. Insofar as the petitioner was concerned, the RITES rejected the application of the petitioner on the ground that the petitioner's drug license certificate could not be verified from the issuing authority database of the website. And further, the license renewal license retention letter issued by the competent authority in favor of the petitioner from the period of 2011 to 2022 was also not submitted by the petitioner in the uploaded document. It is under such circumstances, the application of the petitioner to upload the service catalog was rejected by RITES. Further to that, it is also mentioned that a bare perusal of clause 3 of the general terms and conditions of the GEM portal makes it amply clear that a seller of the service provider, that is the petitioner in the present case, shall be exclusively responsible to ensure that all documents information being uploaded on the GEM portal shall be free from any defects or deficiencies. And in case of any defects, the seller of the service provider shall be liable to bear the consequences for the same. However, in the present case, under no circumstances whatsoever, it was further mentioned that in the present case, it cannot be even remotely presumed that there was any technical glitch or issue on the GEM portal. On the contrary, the drug license of the petitioner was duly rejected by RITES solely due to the defect and deficiencies in the documents submitted by the petitioner. This would have also taken note of that affidavits and replies have been also been filed by the petitioner to the affidavit in opposition filed by the respondent number 1 to 4 as well as the respondent number 5. In the backdrop of the above, this court have also heard the learned counsels appearing on behalf of the parties, whose submissions have been made on the basis of the averments made in the petition, in the respective pleadings, and further to the effect that in the meantime, in respect to the 2 wellness centers, chemists have already been empaneled and they are not parties to the proceedings.
Well, bidder, or it is only one bidder. That is only one bidder to 2 centers.
Have been appointed.
No, it's possible. No, only one bidder, not 2 bidders. One bidder is allocated to your plan. Allocated to two wellness.
Appointed for 2 wellness centers. This court have duly perused the materials and report and have duly taken note of the affidavit in opposition filed by the respondent number 5. From the affidavit in opposition of the respondent number 5, it is mentioned that its vendor agency, that is Rights Limited, have rejected the petitioner's application from being uploaded on the ground of finding certain deficiencies in the drug license which have been uploaded by the petitioner. This court finds it very pertinent to take note of that a drug license is issued in terms with Rule 61 of the Drugs Rules 1945. And the corresponding forms in which these licenses are being issued, and more particularly having a reference to the subject tender, is Form 20, a license issued in Form 20, Form 21, and Form 21A. Rule 61 of the Drug Rules 1945 do not postulate the requirement of a renewal. Rather, a very perusal of the Form 20, the license in Form 20, Form 21, as well as Form 21A, clearly shows that a license, if not shall remain valid perpetually. This aspect can also be seen from the certificate which was issued by the Inspector of Drugs, Kamrup Metro, in respect to the license of the petitioner, wherein it is duly mentioned about a notification of the central government number GSR 1337 bracket E dated 27/10/2017, that a license, unless sooner suspended or cancelled, shall remain valid perpetually. It is also very pertinent to mention that the license of Form 20, Form 21, and Form 21A were inserted, were substituted pursuant to the same notification with effect on 27/10/2017. And in this lawsuit, perpetually. It is, however, good sir, the respondent number 5 or its vendor agency, at least a vendor agency, that is Rights, whom the respondent number 5 considers have to have the basic qualification. To carry out any scrutiny process ought to have known this very basic aspect. While evaluating the certificates of the petitioner, it is apparent that on account of the mistake on the part of the gem, that is the respondent number 5, as well as its vendor verification agency, that is Rights Limited, the situation has arisen. Next. Be that as it may, the question, however, arises in the instant proceedings, as to whether this court at this stage could pass a direction for granting an extension to the petitioner to submit a particular document, or for consideration of the petitioner's technical bid as well as the price bid at this stage, and price bid, more particularly when chemists have been already empaneled to the wellness centers. It is the opinion of this court that passing such an order at this stage would affect the rights of the chemists who have been empaneled to the wellness centers. Apart from that, the petitioner have not challenged before this court its rejection of the technical bid by the respondent number 5. So considering the above, this court is not inclined to exercise its jurisdiction under Article 2 to 6 of the Constitution in the present facts of the case, for which the petition stands dismissed. There shall be no other.
One litigant submission. No more.
The lordship, in the last location, my senior paid for some accommodation if we were absent. Lordship, in view of that, today I'm seeking for adjournment.
My lord, with all empathy to the inconvenience of my senior counterpart. My lord, my difficulty, there is no interim order. The last order also reflects. Only one prayer, if I may be allowed, subject to your lordship. Your lordship has heard this matter as many as 9 times. And there are orders pertaining to the law points which your lordship has taken into consideration. There is a queries made. A response has been given by the state council. May I pray, if your lordship is not taking up, or not taking into consideration the prayer of the municipal council, your lordship keeps this matter as heard in part, because your lordship has heard 9 on 9 occasions. I'm also not, my lord, at this stage of the case, I'm not insisting on interim, because this matter is only now hanging on one point of law, that is whether there was any rules on the strength of which the enhancement of the betterment fees was done. And the affidavit filed by the municipal administration is very clear and categorical to the effect that there is no such rules. So if there is no such rules, then your lordship will take into consideration whether the enhancement is legal person.
Pardons the deed to the council is very
deeply. It with the Lordship. Lordship, this
Eating is also like being. It is an I.
what is that I?
Take the last occasion for us to file our activity right first. However, we have to file that on first petition, we have filed it yesterday. We have served a copy also. And taking the medical prison, he was in Delhi that his father had undergone some of
You're ready to argue? Yes, 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 right. Excellent.
Yes, but it was not. Into if it's still in process, it's not big. It's not clear that it's still being processed, waste is still processing, right?
Give me the written. Yes, sir. Now, Lordship, they have served as a counter, but that protocol, so we are not going on that. If Lordship is see, the issue essentially is this repetition. Primarily is that we are challenging arbitrary action of ONGC in changing our vendor details. Because our case that we as a proprietorship firm have a privity of contract with ONGC. And once the contract was executed, certain vendor details with respect to as well as my GST number, my bank account, was recorded at the system. Subsequently, without innovation or an alteration or an amendment, ONGC acting, if I admit to that fact that the email originated from my email ID. There is no problem. But our case is that, that my email was misused. Certain documents are sent by email to ONGC. And ONGC acting on it have changed all these details. Primarily my bank account, my vendor code, as well as my GST. Once I come to know, I approach them saying that there has been a misuse of my email ID. Please restore it back. The fact that they are not restoring it is why we are before your Lordships. That is the summons
So
of
therefore, assuming the case was going to be short tempered, the fact that whether the terms of the contract permitted a change, the change of the relationship in the petitioner who was the
proprietorship
was
culture.
the proprietor was bidder and whom the contract has been granted. Would have been changed on the basis of mail email. We have to go that the email has been issued by you. Even if an email has been issued, then on the basis of the email is changed.
And the fact remains, we also have to also appreciate the fact that today there is no other agreement.
Then it was, and secondly,
There is no agreement.
secondly, barely on the basis of you. You mean that you have sent a particular document. Can there be a change in the
Essential characteristic.
change in the character of the because here the concern is change from a proprietor to partnership.
Partnership.
If it is a partnership, then the person who will be liable is different.
But here, the liability continues on.
Ah, So
So
the
there,
liability continues only cannot be on another file. Let's say the separate entity. That's the the word is, can there be a reconstitution of the contractor
Contract.
on the basis of?
Without a novation. Section 62 comes in. So that is the sum and substance of judgment, of which Lordship is well aware. So that is the sum and substance. So having done that and having now apprised ONGC, they are refusing to restore it back. Despite the fact that subsequent contracts they have again entered with proprietorship firm. That is another interesting aspect. After changing the vendor code, subsequent contracts by ONGC is again being entered with the proprietorship firm.
For some other,
Some other, no.
some other.
Yes, but with the same vendor code. With the same vendor code, Lordship will appreciate. If they change the vendor code, today they say we have changed everything. Today what exists is a partnership firm. But with the same vendor code, with the same proprietary concern, they go on executing contracts. So now I'm in a situation where I'm executing the work, but I'm not being paid the bills. Because they are saying that because your bank statement and everything has changed. So that is why we are before your Lordships.
That's the term.
Yes, Lordships. Terms of the contract. The contract itself is at Annexure B, page 36, Lordships. I just take you to the relevant portions, Lordships. It starts at page 37, I think so. 36, Lordships. And if I may just read page 37, this contract is made between so and so. The Lordship is there. Of what and Messrs. Rohini Gogoi, a proprietorship firm. Lordship will just mark that.
Include successor,
To include successors.
newspaper. Tutor. It permitted assignment. Whether is respondent number 3.
Cannot be because if Lordship is talking about the transferring of my actionable claims, then there is nothing even there. Then Lordship will come to clause 1.1 contract. Shall mean a written contract signed between ONGC and the contractor, including subsequent amendments to the contract in writing thereto. Please mark this, Lordships. And this, Lordship will kindly read this clause with clause 30. 30, which is at page 65. Kindly read clause 1.1 with clause 30, so that we can decipher the real meaning. Page 65, clause 30. Entire agreement. This agreement supersedes all prior agreements and commitments, whether oral or in writing, between the parties concerning the subject matter thereof. The right of either party to require strict performance will not be affected by any previous waiver or forced dealing. Neither disagreement nor any modification will be binding on a party unless signed by an authorized representative of the contractor and ONGC. And 31. So therefore, a modification, if at all, is signed. But there is nothing on record.
Now
At least
let us see how the communications will be made.
pardon, Lordship.
How the communications will be made.
Communications, yes,
There will be a-
yes. Lordship, before communication, may I just take how modification is to be made? Because that may also have some relevance. Lordship will kindly come to page 42, para 6.3. Sorry, clause 6.3. All modifications leading to changes in the contract with respect to technical and or commercial aspects, including terms of delivery, shall be considered valid only when in writing by ONGC by issuing amendment to the contract. ONGC shall not be bound by any printed conditions, provisions in the contract, which forms acknowledgement of contract, invoice,
packing, and other documents which purport to impose any condition or variance with the with or supplement to contract. And then assignment, lordship, which is the question that followed for assignment, lordships. May I place the clause on assignments?
Now kindly come to this, clause 6.1.
6.1, lordship, yes. Governing language. The governing language of the contract shall be English. All contract documents and all correspondence and communications to be given and all documentation to be prepared and supplied under the contract shall be written in English, and the contract shall be construed and interpreted in accordance with English language. In English. Then lordship will come to 6.4 assignments. The contractor shall not, save with the previous consent in writing of the ONGC, sublet, subcontract, transfer or assign the contract or any part thereof in any manner whatsoever. However, now this is very important. However, such consent shall not relieve the contractor from any obligation, duty, or responsibility under the contract, and the contractor shall be fully responsible for the services hereunder and for execution and performance of the contract. So therefore, I'll just stop here for a moment. So when we are talking about novation, lordships, novation is when a contract is substituted by a fresh contract and a previous party is completely displaced of his obligation to perform under the contract. But lordship will see here that it is not possible. And then lordship will come to clause. Lordship wanted to see the communications.
Email. 7.1, 7.3.
Yes, lordship. So, lordship is fast.
Email channel, invoice, PDF files, and supporting.
Invoice, PDF.
It is only for invoice.
For invoice.
Email channel is only for invoice,
For invoice.
not for changing the basis.
In any case, today, there doesn't exist any other contract besides this contract. That is a matter of fact. And then lordship will kindly come to 32, clause 32. Page 66. The contractor shall act as an independent contractor performing the contract. The contract does not create any agency, partnership, joint ventures, or joint relationship between the parties. Subject to compliance with the contractor shall be solely responsible for the manner in which works are performed. All employees, representatives, or subcontractor engaged by the contractor in performing of the contract shall be under the complete control of the contractor and shall not be deemed to be employees of the corporation, and nothing contained in the contract or in any subcontract awarded by the contractor shall be construed to create any contractual relationship between any such employees or representatives or subcontractor and the corporation. Contractor shall be responsible for the acts, defaults of negligence of the contractor, agency, services, or worker. So even if today they are saying a partnership, it doesn't create a relationship. Now, having seen, in case lordships, and if lordship will see at page 7,
You are referring to
I was referring to clause
32.
32, lordships. This line, lordships, all employees subject to the compliance with the contract. The contractor shall be solely responsible for the manner in which works are performed. All employees, representatives, or subcontractors engaged by the contractor
in performing the contract shall be under the complete control of the contractor and shall not be deemed to be employees of the corporation, and nothing contained in the contract or any subcontract awarded by the contractor shall be construed to create any contractual relationship between any such employees or representative or subcontractor and the corporation. Contractor shall be responsible for the acts, defaults, or negligence of the contractor, each agency's services or workman. And if Lordship will see at page 70, this is signed by Mr. Gogoi in his capacity as the proprietor, page 7. And this position is also accepted by ONGC in their counter, that we have a privity of contract with Mr. Gogoi as a proprietorship firm. This position they have fairly considered, and which is absolutely, let us see your email. Yes, our email, Lordships. Lordships, my email is at page, Annexure F, page 202. I'm sorry, Lordship, this is not the first mail. In fact, my mails are at, kindly come to page 211. In fact, those emails are annexed. The email that I had sent was annexed by ONGC while responding back to me. And this is at page 2. In fact, the document starts at page 208. That is the response of ONGC to me. And the next page is the response. At page 211 is from where it begins. They said these are the documents we annexed to our email. And these are all sent as partners. Lordship will kindly mark the at the bottom of the page, page 211. Paper 264. Page 264. Lordship, page 264. Page 264. Yes, that's the same thing I was reading. Page 21.
When was the agreement entered into?
Agreement was in 31st of January 2023.
When was this email sent?
It is in April 2023.
We will hear to you on alternative remedy. We will argue on arbitration. We will look into it after he makes his submission. We got it on 18th of March 2024. It's not included to do, right? So we can't take into account that. No, can't. We impose a cost upon you at the time. Only- My question is, what happens tomorrow? You now say that we have entered into an agreement with the partnership. It is permissible as per your contract without a negotiation. No. Sir, even not on the matter without the negotiation. Fact, negotiation means make it very good simple. Negotiation means new. In clear contract, it is weakness. The law is very clear that when there is a negotiation between two parties, there has to be, when there is a contract between A and B, and the negotiation has to be there. It has to be in presence of A. B cannot have a negotiation of a contract with B and C. It has to be between A, B, and C. Where A gives up his right in respect to the contract, then B enters into an agreement on the same contract or whatever may be with C. But without A relinquishing his rights in respect to A, the part of the contract, you cannot enter into, because otherwise it will be a case of a discharge by you. It's a case of repudiation by you. It is a case of fundamental breach of contract. Now, are you releasing the amounts to other people? No joint account. You see the partnership deed. Now, what is the partnership out here? Have you seen the partnership deed? You see the partnership deed which is enclosed out there, it is a partnership at will. Now, tomorrow, he just said out there, I want to dissolve. I want to dissolve. What happens? Why they going so bothered about what? My question is out here, Mr. Burwa, my question is out here. The question is, once the partnership is dissolved, then what happens? Where are you? If you say today that there has been a novation of a contract on the basis of this particular document, you have entered into that person. Now, who will be bound by the contract? Is it the partnership firm? No, my question is of now, is the partnership firm or the petitioner? How? Then matter of what? Whom? Mr. Did you sign this document at page 285?
We have specifically stated that this is a forged document, this CR signature. This CR signature. Well, courts will not go into this, but this is not my signature. We have specifically said.
But if this is the document out there, don't you think that it's a possible dispute?
No, no, it is, we are on the only.
No. On one hand, this document is there. As of now, I'll have to consider that this is a document there. See, it is based just on an email. The email is dated 18/3/2020. This is a document which came into existence subsequently, that is the 30th of April 2024. So it was not part of the email.
I'm
So-
sorry, Doctor.
That is not a part of that email. Email is of 18/3/2024. This document is of dated 34/2020.
34, that's not.
So therefore, if this document is 34, this couldn't have been a part of that email.
It is.
It couldn't have been, because 18/3/2024, if the email is 18th of March, this is of 30th of April.
May I just cross check for a moment? So that I apprise lordships correctly.
But I am not going to hold it in their favor to the effect that there is an innovation move. But the fact remains that why should we and I entertain under 226 this dispute? Because when there are so factual aspects that you have an arbitration clause. You can very well go into that arbitration clause which you have. That is an alternative.
Arbitration clause, if lordships read it carefully, this will not come in. Please have a look at the arbitration clause. It is very specific. Kindly have a look at page 59, clause 27. (27.1) arbitration applicable in case of supply orders, contracts with firms other than public sector enterprise. Supply order, this is not anything to do with supply.
Oblique.
Yes, lordship. Contracts with firms, then lordship, there shall be no arbitration to disputes involving claims up to rupees 25 lakhs and more.
The dispute claimed above 25 lakhs and up to 5 crores.
Yes.
In case other party of the claimant, ONGC will forward a list of the 5 units to and so. For dispute involving 5 crores or so and so, the point an arbitrator and communicate the same to the party of so and so. Now, what is your claim?
Our claim is this, please restore her. There is no monetary value here fixed.
Therefore, obviously, it will come in.
We are saying that we are on the arbitrary exercise, and I believe lordships can
No,
under
it is not a-
226.
If this is a document, no, the question is whether it is an arbitrary exercise or not, taking into account the documents, if that document is there, 285 document is there, then how do you take care of it?
No, two fact-based lordships, could you have done this? Could you have now entertained a third party without an ovation? That is the question before your lordships. The question is not this. The question is, can you entertain a third party in a bipartite contract without an ovation?
And if that is done, then the whole law will turn on its head. Here, what are they doing? They are recognizing a third party without the initial innovation.
No, that is one aspect of the matter, whether that question will, that question really arises. But the fact also, one has to see is your conduct.
Your conduct is a document at page two
They have
eighty-five.
already filed a suit.
Who?
Yeah. Let the suit proceed. They have,
Let the suit proceed, but the fact remains out there. Why should we pass an order, exercise our jurisdiction? You file a suit against that.
so
You
what
file
we
a
are saying,
counterclaim in the suit. That is a different thing.
No,
But
what we
why
are
should this court exercise the jurisdiction under 226 in respect to this? This court may very well give an opinion to the effect that there has been no novation. That it is a permissible. But whether the facts, the novation cannot happen in this manner, that this court can very well say. But other thing as to whether it has happened, all these conduct which are there, if this document at page 285 is there, this court is not going to
all
learn.
that we are seeking lordships today is that if there was a no novation, then the original details have to be restored back.
But this is your document. I would have understood that he has signed it, the other person has signed it. But this 285 is a document which comes subsequent to the email. My question is that.
May I
is it
just-
also-
I just another aspect of the matter, lordships.
But it will be otherwise a case of a reputation. You see, the thing is, if you don't enter into an agreement and you consider him as an entity somehow, or not him, the partnership as an entity, the contract has already been repudiated. The contract is discharged. How? So therefore you say that remains the same. So therefore now he is asking to change it. You are not changing it, why? No, you say the contract remains as it is, no problem. Now, you have used a different PAN number for deduction of tax. You have now used a different bank account for the purpose of here. At whose request? His. Now he says that no, forget about all these things. I'll never dispute all these things. This number, kindly don't put it. Kindly put it in this number. Why you are not doing it? No, where is the civil court is pending means? But is there an injunction not to change it? Then no, the question doesn't arise. So he has been requesting you that kindly change the bank details and the PAN card details. Don't deduct this tax on this amount. You yourself say that you still continue to hold MS Rohini Gogoi, whether you are not concerned whether it's a partnership firm, that you are not concerned. You are still holding him as the person. At his request, you change the bank account. Now he makes a request to change the bank account here. You change the bank account, matter over. What is the problem? If that is the only case, if you can do it at his request, then obviously do the request. And he's making another request. That's all. Simple. You are not bothered to them. Are you bothered? Have you entered into an agreement with you? So you categorically say you have no privity contract with the private respondents. You have no business out there. Your contract is with him. At his request, there cannot be a change, because if you change it will be the contract has been repudiated at your end, which you can't afford to. It will have far-reaching consequences. So therefore, the only thing is, if you have changed only his bank account and PAN number, change it. And thereupon, whatever has happened, all other things will be subject to the outcome of the suit. But now you change it, matter over. Yes, I think. Partnership deed, why should we look into this partnership deed? No, I'm not concerned. No, man, no. First, you tell me. In this contract, can there be, without the novation of a contract, can the partnership, the entity enter? No. Where? Where is the contract? How? Where? How? How? Where is the document? Show me your document to the effect that now the ONGC regards that it is the partnership firm which we are dealing with. No. That is not in. No, Mr. Counsel. No, nothing doing. Unless you show me that the ONGC by written document have modified the terms of the contract, which was entered into in the year 2023, nothing remains. So what? You may be a subcontractor. No. Can the partnership deed override all these things when the contract is there? So what? That is a subject matter which he'll challenge it. He has 3 years to challenge the documents. Fantastic. Go and ask the money from him in the suit. Mr. Sharma, your question is simple. You have entered into this agreement, you have invested some money with him. For doing this particular work. You are entitled to some money from him. That is a different aspect which is depending in the civil court. No. Where? Show me one document where the ONGC has accepted the partnership firm. No. Show me the document by which the ONGC has accepted the partnership firm. No, not affidavit. Show me a document by which the ONGC has accepted the partnership firm. I hope I don't need to repeat to you in Assamese if you have not understood in English. Show me a document which will show that the ONGC has accepted the partnership firm. That's it. That is still in the name of Ruhinidas, Ruhinimur. Only change which has happened as per Mr. Bolua is yes, as per him is only the PAN number and the bank account, nothing else.
GST number. GST.
The contractor is discharged. There's no existence of a partner. Unless you have agreed, there's no contract. When the proprietorship is dissolved, first of all, I hope you understand, I hope what you are making the submission, even assuming for argument's sake that is right, what your submission is right, let us assume that, then it is dissolved. Second, if what his submission is completely misconceived, because the proprietorship is only a trade name. The basis is him. He still continues to remain. So he cannot be dissolving himself unless he's been declared insolvent by a court of law, which has not happened. So therefore, your submission is dissolved. Not necessary. Okay, we declare. I think you have to go there. What makes big court does that? Why should I? My question is there cannot be, as ONGC still says that the contract is in existence. You say? So therefore there is no novation. If there is no novation, he is asking you to change, the thing. And you report it to the GST authorities, whatever this illegality they have committed, pick it up. That is your lookout. They cannot. It cannot happen. By action of the party, when a document is written, it has to be by way of a written document. I'm not passing an injunction here. You are able to get that injunction, fantastic. These observations which are being made here will have no effect on the suit. I'm grateful. Okay, let me dictate. You are not releasing any amount to anybody. Are you releasing any amount to anybody? That will be all subject to which is there before the suit if he gets an injunction. Otherwise, you release as per him because you still have a contract with him. So when he has already made a request, you have to adhere to it. Otherwise, it will be constituting the breach of contract. This court is not opining anything about what all these documents are there because these documents Whether it creates a right upon him in the suit is a different aspect. He may be filing a suit out there before the civil court. The civil court, what is he going to ask? He must have asked. He must have asked about that I should get this money and all these things. I have invested the entire amount for myself. I did all the work. And if he is able to prove, he can be paid, get the money from him. But between you and him, that is very clear. So if he wants to get the money from him, get it. Right? You cannot. That is no. Unless they will. Can your, have you mentioned out here that the office memorandum shall override the provisions? Matter of, because unless, you know, to the office memorandum, you have mentioned anything as regards the governing laws, jurisdiction and applicable, the agreement including all matters connected with theirs shall be governed by the laws of India with substantive to the time being and subject to the exclusive jurisdiction of Indian foreign companies. There's no mention about any office memorandum in it. You get an injunction before the trial court. That's all. Let them put it in. Get the input from the court. Subsequent that
Same contract extended. Page 239, Lordship, why should they say yes and no? It is page 239. I am not making a speculative argument. The same contract has been extended for another 6 months. That's right.
no, is it any other contract?
No, then we have bidded for more contracts.
Now, have you got any other contract?
We have lost on the financial route. Technically, we crossed through. There was never any objection. And this is in 2025. They still again extend the same contract with the proprietor. Accept a bank guarantee from the proprietor against his extended contract. On one hand, they say we are recognizing the partnership. On the other side, they extend it to the proprietor firm.
Now, what is the vendor code for the partnership firm?
Please, and kindly have a look at page 240, my acceptance as a proprietor. See the bottom of it.
Now tell me here. Is the document issued to Lumini, MS Lumini Google, BC so and so? Wait. In this context, You are requested to provide your consent to carry out the above work service on the same rate terms and of the existing contract. Now, see. Winning over rights to this as a proprietor, and you run the extension on 2310, then can you now say it is dissolved? My question is, can you now say it is dissolved when he writes not as a partner, but as a proprietor? So. Oh, but here also, because why I say so, I won't say otherwise. Otherwise, I don't give so much an importance to a private respondent's arguments. Kindly see it. Why I think so. Second, interesting. I'm not going for that. Here, now here you say that there's no longer a job. Now if it is job, if that is the basis to do it, then why on earth later on you have, as a proprietor, yes, kindly, you have accepted it on the day. For your legal help. Some legal help. Legal person.
39 is even more revealing in the sense that it is, they are accepting it because you see the address also. That is the address of the proprietorial firm at 239. Where they are annexing. Negative. Upon. That's it. Will find the reply or no?
I find.
It can bring it. Because later on you will say that this code, because the judgment. It will be reaching people. We have a copy of it. We have a soft copy.
This step I filed it. Person mentioned if otherwise I would have got it. And even morning, he was clearing the backlog of this. I did not clear the data. So Lordship, it's me one more day tomorrow. I'll send it.
But extra copy is. Extra copy. And itu sabor itu. Itu tak. Itu
Yes, where we denied this document at page 289 in your affidavit in reply? 284. Where we denied the existence of 284 in your affidavit in reply?
284 is the affidavit, Lordships.
284 is that document which they have submitted, the indemnity bond.
Yes, I understand, Lordships. একটা ফোন উঠে গেছে। হ্যাঁ, আগতেও দিছো, সেটা একটু। হ্যাঁ? হ্যাঁ, show me that. Please give me a worship, please. Two.
And Mr. Bulwa, tell me. Here, if you look into it. In one of your legal persons say that the affidavit submitted by the vendors seen and it is desired that the following clause may be added as an additional clause. Understood? That I am reading over, and this is seen at page 285. How did you communicate with him? Where are those emails?
Nothing
Which
is
led to
communicated.
this document? So this happened on 29. They gave it on 30. So therefore 29 ways that email. Huh? In person.
No, that is.
When did he inform that the email was hacked? So he informed. No, my question therefore is interesting. You see this particular document, he has mentioned that the email was not properly done. The affidavit. He made a complaint. Where is this complaint?
How many in-person people go in?
Yeah. He gave a complaint on 29, 27/9. I submitted a bill for the amount of
20 to 5 Lordships.
50. Fraction was another. Which is having concern with my. It is only for his bill, but where has he informed that my has been wrongly used?
No. How can I, that is what, let them not, let the facts, I want, place the facts clearly. We issued a legal notice, say that please give me all these documents, I need to file an FIR. But what is important is that very important query which Lordship have passed, they avoided. Was it submitted in person? Kindly come to page 209. The email to them, the email they replied to me, and now the counter affidavit stand. Please have a look. This is a very significant email. Please refer to your letter number so-and-so dated 22/5/2025 with regard to some changes in the vendor code 824091 as you claim in 17th April 2025, as per your claim later, nobody came to office Nazira for any changes in vendor code 824091.
This is dated when?
This is dated 4th of June 2025. This is responding to my email. Now please see the stand he has taken here. And then you see the entirely opposite stand he has taken. This email, Lordship will see immediately the last portion of page 208.
22nd of May.
No, 22nd. No, this is 4th of June, Lordships. Kindly have a 208 page bottom. Bottom of page 208.
You first sent on at page 204.
204, yes.
Okay. Yeah, 204, you first sent it on 22nd of May.
204, yes, Lordships.
The correct changing of the document.
Yes, Lordships.
Now, this is given now. May. Now, you can see.
No, we sent them several communications. We sent them several emails. Finally, they responded on 4th of June.
No, understand which are the previous, earlier one, I see it out there at page 197.
Yes. So and then finally we,
27/9.
then we sent
Where
them,
have you mentioned that your, some answer person on so and so?
if I may place that, Lordships, 209. If I may place 209, Lordships. This is the response to all my emails. Please refer to your letter now dated 22/5/2025 with regard to some changes in vendor code so and so as claimed. In 17th April 2025, as per your claim letter, nobody came to office Nazira for any changes in vendor code 824091, nor any changes had been made. Your bank details have been changed in 2024 in the month April, May as per documents submitted. Those documents submitted were duly signed by Ruhini Gogoi himself, and you yourself had authenticated those documents in front of the undersigned.
Front of Manoj Kumar Duloi.
No, that is now this stand is not taken in the count.
It's okay, but this is a document.
But this stand they do not reiterate. They said only we received email. No, me coming to office is not preferred in the counter affidavit.
But this document is there. Are you denying to this?
Yes,
Where?
because he himself accepts it.
Where have you denied to the fact? Because what, Mr. Goswami, one has to also understand. All these things happened in the year 2024, March and May.
Yes, between them.
Vendor code was changed after your submission of the indemnity bond on 30/4/2024. 24. 30/4/2024.
Yes.
Now, this is in pursuance to 29/4/2024, where there is a discussion and there is a insertion required as regards this paragraph out there. You have not denied to the execution of this document.
This is their email.
No, this page 285. You have not denied to the execution of this document. Page 285.
I have that
Where?
affidavit, Lordship.
Ah.
I'm just trying to find out just give me a moment. We have denied it very specifically that the signature is forged. That is what I remember reading it. I'll just point it out.
The problem lies is,
But,
you see,
but ultimately, Lordship,
seen it, your other affidavit signature is this only.
but ultimately, Lordships, what is to be seen is, can they be, ultimately, we have to see it in the light of section 62.
Maybe, but in this court also has to see it in the light of.
And
the
what are we saying?
26 as to whether it's a case of you appropriating and reprobating at the same
Because
time.
it is our
Because
case,
you see,
our email
you
has
have immediately involved. You knew about this thing. More particularly, your document at page 197 shows 27/9/2024. After that, you keep on writing about some letters to all these things. You have never denied to these that you have not executed this indemnity bond, or this is for the first time you have come to learn. Now, here, this document further shows the 209 that you have changed it in front of the undersigned.
Lordships,
That is their document.
Lordships, this is, and the same gentleman avers of affidavit, Lordships. Kindly see his averment in the affidavit. This,
Forget about the affidavit. This is a document which you have enclosed. Where you are. You
this is his
denying
reply
that-
email.
Where is your statement that you have never been to that place, their office? Where's
Yes,
your
yes, yes.
statement? No, no, I've seen it. That is immaterial. That's. Court should not exist. That's all right. I think Mr. Goswami, you need them to-
Oh, Lordship, kindly give me.
I don't think this is a case for.
Lordship, kindly appreciate. No,
No, these are the thing.
give me, Lordship, let me at least give me the liberty to respond to Lordship's query. I may be able to satisfy, I may not be able to satisfy. But let me at least try and respond to Lordship's query so that I go back with a feeling that I have done my duty. This is for the court to decide. It should not be that I have not been able to respond to your Lordship's query. Because sometimes Lordship's files help. I'm getting. Please come to page 230. 231.
Yeah.
That so and so has lied on record in his email dated so and so that my client, Mr. So and so himself authenticated documents.
No, where do you affidavit?
Pardon, Lordship. This is
Where's the statement made in repetition that this is a false document area. Because here, why I'm saying so? This is happened on 30/4/2024.
yes, Lordships.
Thereupon, and this happened prior to on 29/4/2024, as it appears from this document, that there was the legal said that we required this particular statement to be inserted. Thereupon, you have inserted this particular document and then signed it. Where have you denied to this execution of this document?
The document of that affidavit under, yes, affidavit Lordships. What we have denied is what I have told you, nothing beyond that. That we are denying his execution because it is not our signature. That is to that only extent we have said. I have read that.
Where?
In our reply.
Where? That is what I'm not finding. Get a photo.
Please give me a moment. I'm sorry I'm taking up some time. Yes, Lordship, will kindly come to. Now kindly come to Lordship's para 21 of my writ petition. Thank you for the kindness.
Of your writ petition,
Yes, on affidavit, Lordship.
of your affidavit in reply.
My writ petition. And with respect to the affidavit 34/2024, the averment is at page 19, para E.
This is your, the writ petition.
This is my writ petition motion. Para 21, lordships. I am responding to both the email, lordships.
Letter dated 27/8/1997. You are saying that this small, the short signature is not there. But your entire petition is drafted on, signed here.
As it may, I wanted to show that this is, we have responded to it, but the
You
fact,
responded before the filing. Before they filed the reply. So you knew about these documents of 34.
yeah, we have responded to that also.
No, so you had this document of 34. That is the port's document.
Yes. But no originals with us. Therefore, in the legal notice, we had asked for that, please give us, to facilitate us to help file a police complaint. Ultimately, the eagerness of ONGC to retain the partnership is something.
Have you filed the police complaint?
Yes. I'm just kidding. We never have access to these original documents.
Not necessary. They can always seize it.
That instruction we have to take, lordship. He just says he has to take that instruction on whether an FIR has been filed or not. But the fact remains, lordship, I am only on that aspect of ONGC exercise of power. And today, when I'm requesting them back, what is it some internal administrative law or some external administrative law or rules of fair practice for which it is preventing them? Once they concede that the contract still exists with me, what is it? What is it preventing?
Whatever may be. At your instance, we have to consider that at your instance, they have changed it.
No, lordship, that is what I'm saying. Our case is our email was hacked.
So where is it?
Misused.
You mentioned in your letters that your email was hacked.
Yes.
No, that is what I could see. 197. There is nothing mentioned to the effect.
Oh, please see, lordships.
You say that you kindly see page 202. I'm right. This is written again on 20th of May 2005. Now, prior to that, on 27/9/2024, when you wrote this letter, so and so accordingly, you categorically say that so and so I submitted the bill so and so, and mischievous activity and cheating committed by so and so in a newly considered, whereby my decade-long bank account, which is automatically connected with my son, was changed to some other so and so, so and so. That is here you have not mentioned by way of an email. Maybe you may not have known about this at that point of time.
I didn't know about it, lordships, at that point of
But
time.
at that
It
point
is
of
only
time,
later on when I was sent
you
this.
came to know only after 4/6/2025.
Yes, lordships.
That these are being done on.
Yes,
thereof-
yes, lordships.
And thereafter,
Thereafter, I asked for those documents. And when I requested them to change the vendor code back, they simply refused, which has forced me to come before this court. Because lordship, so if anything, because lordship, you see, it is my case that today I have done every work, I have executed everything, and today I am running pillar to post.
you need the money from them.
How do I?
I didn't see.
So I have
Proof these documents.
No,
that you have
lordships,
not submitted.
I am reiterating what is say. I'm sorry, I'm repeating myself. But what today is falling for adjudication is the exercise of power by ONGC. Is the exercise good in law or bad in law? Could they have done it without an ovation? Is what is fallen for adjudication before your lordships? Nothing more than that. We are not here who is going to get the money. That he has filed a suit, the suit will take its own course. But today the exercise of power, both without there being an ovation, and secondly, acting on an unregistered partnership deed, Could a state have acted and changed the partnership details only on the basis of a notarized partnership deed? Wait, I'm not completed my, please. It is a registered partnership deed after the change have been effected, not on the date. The date on which the change took place, it was just a notarized partnership deed. And that I'm saying with complete responsibility.
Don't require a partnership deed to be registered, whether the registration is there before the register of partnership.
That is after the change were effected.
Maybe, so it requires.
As a state,
Partnership.
as a state, would you act on would you novate a contract if I'm assuming it's novation? Novate a contract on a partnership deed that is not even registered?
But this is being shown as being done at your instance.
Again, I'm re-emphasizing, Lordship, this is something that which was misused. If it was done at
So
mine,
therefore, if it is a case of misuse, it's a question of disputed questions of facts. Why should I enter? My
there is
problem
no
there.
question. There is today, what was before ONGC to do whatever they have done.
Okay, hearing completed, judgment reserved. I'm not going to all these things. My question is whether he has gone or not, these are questions to be looked into. And the money, if it is not given by them, it is whether they have done it on their basis. Let me think.
Because today, Lordship will also consider that I am till today executing contract in the name of the firm, of proprietorship firm. Contracts have been granted to me in the name of the proprietorship firm. What would be remaining the status of that?
It will remain as the name of the proprietorship. The question is not that there has been a novation. I would not recognize that there is a novation in the firm of the year. But whether you have asked them to change it at one point of time and later on, and by giving all these documents, now whether they are justified in not changing it. That is the question, which is a question of fact.
Unless no,
You are denying to that fact that page number 12. I will hold it that there is no novation.
no, if there is, so Lordships, kindly appreciate one thing. I know Lordships, I'm keeping Lordships waiting. If there is no novation, Lordship, the question would again come, from where do these new details come in? Could you have incorporated it by what? Which law? Which law would provide for incorporation of these new bank details without there being an amendment, alteration, or a novation without a written agreement? Can it be done suo motu? Because Lordship will appreciate it has to be either alteration or an amendment or a novation completely.
The contract that the bank details which are there cannot be changed.
But there has to be a mutual. That is what I showed clause
That
30.
is what the documents are showing.
But clause 30, Lordships, let us revisit clause 30 once again.
Do one thing, don't pay anybody any amount till the finalization of the suit.
No, that Lordship,
That is a better option. That is a better option.
No,
What do you
that-
say?
Lordship, that will abide the suit. But what I'm saying is that if today they concede that there has been no amendment to the contract,
There's no amendment.
there is no amendment.
Whether they say or not, but whether you can ask the change of the payment to these particular bank account. We are only concerned with the bank account.
Lordship, I think so. I'm not made myself clear.
Not, after hearing
It is my mistake.
three
It's my,
hours. Either it is the fault of yours.
it is
or
my
it's the
mistake,
absolute
Lordship.
fault of mine.
It is my mistake. It is my mistake. I concede, but I have not made myself clear. Just 1 minute, Lordships. What are we seeking? We are, if today they concede that there is no amendment, then at the same time, how do they change the bank details? Is that not an amendment?
Is it the bank details mentioned there?
Lordships,
Is the bank account details mentioned in your contract?
that is what I said, Lordship 6, para where it says commercial conditions can also not be changed. That there,
Understood, but that doesn't mention about the bank account.
it may not mention about the bank account, Lordship, but commercial, when you are using that word commercial components.
It is for division bench. They have good judges.
No, Lordships.
Sorry. They have not filed it. Yes, moving on. We have it again.
Pardon, Lordship?
The hearing remains unconcluded with this matter again on 23rd June for further hearing.
At 23rd?
23rd June for further hearing. In the meantime, the registry shall bring on record the affidavit so filed by the respondent number 3 and 4. Sure. Huh?